the land matter, my lord, you mentioned, moved this application, you lord, refer the matter to Panchayat, my lord. On that ground, let the matter appear to me, mention, my lord, you refer the matter to land matter. My grievance is, my lord, fill up the font. You lord, refer the matter to Panchayat, my lord.
It was within the Panchayat determination.
Land matter, land matter.
So where the matter is, you can mention it over there. Why it has to come back to me? It must be there before some other bench. It has gone before some other bench.
No.
Then?
Otherwise, my lord, if you lord not correct the matter, my lord, then my lord, again I will trouble there.
Give the number to be mentioned.
My lord, subject to the leave of the court. Item number 362 of the lordship's test list. It is under the heading of the application. In the last occasion, my lord, that is on 12th June of this month, this honorable court was pleased to exempt the personal appearance of the contemptor. And also 20,000 cost has been imposed. As the contemptor shows the bona fideness that by 19th of this month, they will...
What you want?
My lord, in spite of commitment, they do not comply.
Yes.
Their own commitment.
Yes. Then what is to be done?
As the matter is coming before the lordship, item number 362, lordship kindly taken up this matter today, my lord.
Yes, I will take it up. Give notice to the other side.
Yes, Lord,
Do not mention at 2 o'clock. The list will be called on. At the time of rising, bring your other side. I'll take it up.
My lord, I have already served the notice upon the other side.
Bring your other side.
My lord, kind leave, my lord. May I mention one matter for update?
To mention item number 405, my lord, application for restoration, my lord, kindly take.
Why are you mentioning? It is there in the list. It will be taken up.
At the time of, my lord,
Restoration, it was your fault. Nothing doing.
Item number 384, my lord. The order was passed. It's more than 1 year, my lord. It has not been properly implemented, my lord. Hearing is given, but order is...
Lordship, may I be permitted to mention a matter, your lordship? This is your lordship's order of 20th June, your lordship. While passing the order, your lordship has granted the petitioners to the liberty to mention the matter in case any coercive steps have been taken by the respondents, your lordship. Your lordship, it has not been recorded in the order, your lordship. It may kindly be considered.
It may not have been recorded, but in case any steps are taken, you please mention. It is not required to be recorded. Mention. Item 1.
I appear on behalf of the petitioner. My lord will peruse my lord's last order,
Yes.
which was passed on the 12th of June, 2025. It may come back to my lord in spite of expressly holding that there were unauthorized constructions and in spite of...
The commissioner was directed to file a report.
Where's the report?
Yes.
What did we have not served us? We have not been given a copy of the report. Although a copy of an order, we have not perused the report. Maybe come back tomorrow, my lord, after reading the report, because from the order, there are certain things which I need to point out, but strictly speaking, subject to my lord's pleasure.
Go through it and come back. A report by the municipal commissioner signed on 2nd July 2025, filed in court today, is taken on record. Copy of the same has been handed over to the learned counsel representing the petitioner in court today. Release the matter for further consideration on 10th July, next Thursday.
Grateful, my lord.
To appear for the petitioner.
Malad, I appear on behalf of the state. Malad, I'm
Chakraborty is online.
Personal appearance of the special officer, Malad, executing be dispensed with, Malad.
Was there any direction?
Today there are direction.
All right. The personal appearance. Is anybody present? Who is he? Who is he? Who was the on whom the direction was passed? Dekhi 1 minute order ta. Contemptor number 4. Who is the contemptor number 4? Where is he? Not come? No. The contemptor number 4 was directed to remain personally present. Stop. He has not appeared in court and no reason for his non-appearance has been placed before this court. Stop. He is directed to remain personally present on the adjourned date. Yes.
But to apply for the petition, my lord, led by Mr. Chakraborty, is probably in online.
Madam, for the state, I'm holding the brief of Mr. Shopun Banerjee, my lord.
Yes, start. Let him join.
My lord, matter relates to, my lord, the petitioner was appointed as a marriage, unofficial marriage register. And there was sometimes on October 2023, he was served with a notice for certain clarification. He issued a reply and submitted all the documents. No reason order was passed. Your lordship.
Now a reason order has been
My lord,
passed.
reason order was passed, my
First
lord. We
August
are
9.
allowed to join, and a disciplinary proceeding was initiated. A fresh charge sheet in terms of your lordship's order. A fresh charge sheet has been issued, though all the charges remain same. My lord, and I was called upon to participate in the proceeding. Your lordship kindly sees the order passed by your lordship, which is appearing at page 131. Your lordship
131.
131A.
All right. Yes. Yes.
Your lordship was pleased to your lordship was pleased to, my lord, set aside the earlier round of charge sheet and granted liberty to them to give a fresh charge sheet. That was done. Though the entire contents of charge sheets are the identical thing. My lord, I'm not. We submitted a reply. Well, after the reply was submitted, straightway I was called upon to join, to participate in the hearing, which is at page 162.
Yes.
No list of documents, no list of witness. On that particular date, it's at page 158. I stand corrected. 158. I was called upon to join on 3rd June 2025. I joined there. I went to participate, and I asked for certain what are the documents, because the documents which was asked for, I've already submitted way back in the year 2023.
You have been directed to inspect the documents.
Well, that is, well, list of documents were not given, and the documents which they want to rely, that I have submitted way back in the month of October.
Very well. Now, page 162. Do you have any other volumes, or this is the last volume?
Well, this is the last one.
Page 162 is the last page.
Last page.
Right. You have been directed to appear for the purpose of inspection of documents in connection with the articles of charges. Where is the difficulty?
And my lord, it comes to my representation.
Disciplinary proceedings is going on.
Representation, my lord, at 159.
Why?
My lord, my lord, threefold.
Before that, they have initiated this writ petition.
No, maybe. You go there.
No, my lord, I want, my lord,
the difficulty, my lord.
1 minute, please. Yes.
I want legal assistance, because I am not in a position there. The particular disciplinary proceeding involves interpretation of certain rules. I wanted, my lord, kindly come to page 159.
You apply before the authority?
No, I was not permitted. Advocate was not permitted to.
You apply before the authority
this
seeking
is my
permission.
application. This is my application at page 159. I went there. I asked what the list of witnesses and the list of documents, that was not given, and also I asked for legal assistance, because I have stated that as the matter relates to the Department of Law, and I am not a legally qualified person, I want to be represented through an advocate. That was rejected, holding that rules doesn't permit, and subject to correction, I am not a holding a civil post. Therefore, West Bengal service rules will not be applicable. And this particular.
But why is it is your personal matter? You can always go and say what your case is. Why do you want the assistance of a learned advocate?
I tell your lordship, certain charges were there, which cannot be considered as misconduct. I may place the charges. The charges says there are mismatch, no complaint, any sort of from any person, and the thing, my lord, may I just explain this way?
Are you not permitting the legal representative of the petitioner?
The number of occasions, my lord, she has paid adjournment, my lord.
Wait,
whatever is gone is gone. Are you permitting a legal counsel to be there?
My lord, I need to take instruction, my lord.
The disciplinary proceeding against the petitioner is continuing. Stop. The petitioner seeks assistance of a legal representative to defend her before the disciplinary authority. Stop. Learned advocate representing the state respondents is directed to revert with instruction. When?
My lord,
Next Thursday? Next Thursday? Next
my
Thursday.
Mr. Shopper
10.
manager is on his way, my lord.
Cannot help. Somebody who's not there, his name cannot be recorded. Yes.
Grateful Lord.
These bunch of matters, my lord, your lordship was probably hearing on the last day. Mr. S.N. Mukherjee was making his submission.
All right.
On which item? Item number 4, he was making his submission, my lord.
All right.
But I am in item number 3.
Hmm.
But I am I am not a director as such. I am a technical person. As a professional director, I was in the board. So my case is slightly different, though the major points are common. Like the major points which my Mr. Mukherjee had argued, that the
Yes.
first committee's order, identification committee's order, the review committee's order, what is the constitution of the committee, that is not in terms of the clause 3. Secondly, my lord, it has been argued also, if your lordship sees the orders, it does not appear from those orders that the order has been passed by the committee. Order, if I may just show your lordship once in my case, from the document in my case, if your lordship takes the writ petition, item
Which?
number 3,
Yes.
kindly see
Writ petition 420, 520.
Biplav
W4
Shankar
Biplav
Bose.
Shankar Bose.
Yes. Kindly take volume number 4 to them.
All right.
I am showing your lordship the order which has been passed.
Hmm.
Kindly come to page 437. This is the communication.
Yes.
Kindly see, this is dated 15th January 2024.
Yes.
Then kindly see this, I am not placing this. Kindly see page 438. At the bottom, enclosed copy of the order dated January 11, 2024, issued by the Willful Defaulter Committee.
Hmm.
Next page, the order starts at page 439.
Hmm.
Kindly come to the last page of the order at page 449. By the order of Willful Defaulters Committee, Murali Sarasan, member of WDC stroke authorized signatory. From this document, it appears that this person, as authorized signatory, has issued an order, apparently by the order of the Willful Defaulters Committee.
Hmm.
Now, kindly take paragraph 5 of this page 448.
Yes.
WDC, in its meeting held on November 20, 2023, deliberated on memorandum and submission made by DG and noted the following.
Hmm.
Now, Lord, when we took this point in their petition, they have disclosed this minute in their affidavit in opposition. I will now show from their affidavit in opposition this particular minute that this deliberation never took place in that meeting. Kindly have a look at that meeting minutes, my lord, as from the affidavit in opposition, which is at page 24. 24 of the affidavit in opposition.
Yes.
Yes. Well, 23 it starts, my lord. Minutes of the 8th meeting of Willful Defaulters Committee held on November 20, 2023. All members were present. Committee confirmed the minutes and summary such and such. Next, my lord. Next page. Kindly see. WDC deliberated on the proposal submitted by the dealing group to take note of submissions made by ex-promoters. Then, my lord, and final opportunity of final hearing before on to, and then to take a view to declare them as willful default after taking into consideration replies given by them. Now, my lord, committee noted that such and such did not appear. After deliberation and discussion, WDC passed the following resolution. So what is the resolution? Resolve to issue an order recording the events of willful default committed by ex-promoters, directors, guarantors of such and such. Number B, WDC authorized ED to sign the order mentioned at A above. So this is the resolution to say that an order will be passed recording the willful default, and ex-ED will be authorized to sign. Now, what is there in that order, which I just showed your lordship in paragraph 5, is not a part of the minutes. So my submission, my lord, if your lordship now comes back to the order which I was showing at page
48.
448.
Yes.
Kindly see, there are several points which are noted in paragraph 5.
Yes.
This, your lordship will not find in the minutes of the meeting. Minutes only record a resolution that an order will be passed. But that order is not on record to show the entire committee has applied their mind and come to the conclusion as regards these findings. Then, the next paragraph, your lordship will see. Number 6, the WDC therefore concluded. So the conclusion comes after these findings. Findings are not there. WDC therefore concluded that promoters, directors, such and such, are fit to be declared as willful defaulter in terms of clause 2.1. At the most, I can say, my lord, from the minutes, paragraph 6 will appear, but not these findings, which are in 5, based on which paragraph 6 conclusion is arrived at. Then your lordship will kindly see paragraph 7. On perusal of the records and having regard to the facts and circumstances of the case, the committee recorded its findings as under. Again, my lord, your lordship will not find that this finding is there. So, my lord, my submission is this order passed by the identification committee is not the order of the committee. It is not evident that the committee deliberated on the show cause notice, reply, and other reports and came to the finding which is recorded in paragraph 5. Because they themselves have given the minutes of the meeting. Now, my lord,
prior to this position.
Next, my lord, so this is the first challenge when I move the writ petition, that this identification committee order itself is bad. So when we move the writ petition, they said that the review committee has already passed an order. And my lord, we have taken this point in the representation to the review committee. That is the next stage. I'll show your lordship that also. Your lordship will kindly see the representation to the review committee is at page number to follow. It's just next page, my lord. 450. Kindly see, second paragraph, it is stated that the order dated January 11, 2024 and purported finding as to willful default contained therein are not tenable, is not in accordance with the master circular on willful defaulters dated such and such. There exists no willful default and the purported order is such and such. Then we have said that it is stated that the committee which passed the purported order was not constituted in accordance with the master circular. As per the master circular, the willful defaulters committee must comprise of an executive director or equivalent and consisting of 2 other senior officers of the rank of GM, DGM, order dated such as purportedly signed by one only Sarajan as a member of the willful, and therefore there is no committee in accordance with the master circular. Then, my lord, I have given my status as a professional director. I was not involved in the management of the company. So when I gave them this representation, then also, my lord, they did not come up with this minutes or yes, this was the constitution of the committee. The committee's deliberations and the findings were this, which already existed prior to the order which was signed. Now, my lord, same thing your lordship will find with regard to the order of the review committee. The order of the review committee, my lord, we have disclosed as part of the supplementary affidavit because it came after the writ petition. Lord, that your lordship will kindly find at page 14 of the supplementary affidavit. Page 14 is the communication. Then from page 15, the order of the review committee starts, my lord. Kindly come to yes, page 29. Kindly see page 29 where the ordering portion starts. WDRC carefully examined the contents of the written representation received in response to order issued by WDC dated January 11, 2024 and observed that the written representation have not brought out any new fact, law or material that has the nature of changing the decision of the willful defaulters committee of the bank to declare them as willful defaulters. So, my lord, here kindly see this is also in violation of the clause. It is named as a review committee. It is not only the forum of review. It is like a forum of appeal. I have all points I can take in the appeal, and the authority has to apply and decide afresh on the basis of all available records. But here it is as if it is exercising review jurisdiction only to see whether I have given any new fact which is not there before the first stage. That is not the consideration. My lord, if your lordship will kindly take once, my lord, take the writ petition where I have annexed the circular and the rules at page 462.
Yes.
Kindly see, my lord, rule 3, mechanism for identification of willful defaulters. A and B I am not concerned right now. The last stage, my lord, is C, page 463. Order of the committee, first committee should be reviewed by another committee headed by the chairman, managing director, chief executive officer, in addition to 2 independent directors of the bank, and order shall become final only after it is confirmed by the said review committee. However, if the identification does not pass, and that is not important, so it should be reviewed. The word, so this is it is the second stage. I get another opportunity. But here, my lord, kindly see, they have only proceeded on the premise that I have not brought out any new fact. Not just it's as if importing order 47 rule 1. That is not the purpose of the second stage. It is a second stage to give you another opportunity to before the final decision is taken at. So the order starts here. Then again, same your lordship will find page 30. By the order of the willful defaulters review committee at page 30. Again signed by only one person, chief general manager. Here, kindly see, they have also disclosed a minutes. Then kindly, my lord, again comes back to the affidavit in opposition where the minutes of the review committee has been given, page 30.
Yes.
Kindly see, directors present, such and such, MD and CEO chairman, such and such, independent director, another independent director. Following members attended the meeting, kindly note, for presenting the agenda items. And my lord, kindly see the last name, who is the person who has signed the order. So my lord, my submission subject to correction will be, my lord, it is not that all 3 and 7 persons deliberated on the entire issue. The next 4 items, persons present, had only presented agenda. Actually, their deliberations are by the first 3 persons. Order is signed by person who is not participated in the deliberation. This CM Subramaniam.
Yes.
Next page kindly sees, my lord, page 31. First paragraph at page 31, para 5. The WDRC deliberated on the memorandum dated March 5, 2024, seeking to review and confirm the order passed by the Willful Defaulters Committee to declare the promoter, erstwhile directors of EMC Limited, as willful defaulters in terms of the following RBI circular and report to credit. Kindly see the first 3 lines. Deliberated, review committee deliberated, seeking to review and confirm the order. Declaring, confirm the order passed by the defaulters committee. Therefore, you proceed on the mind that my agenda is to confirm that order. I have come to the conclusion of affirmation. I need to only give reasons in support of my conclusion. It is not findings, analysis, findings, and then conclusion. Conclusion is preceded by the finding. Then your lordship will see, after discussion, WDRC passed the following resolution. Resolved. Promoters, erstwhile directors, guarantors of such and such are fit to be declared as willful defaulters. May I ask, where is the reason? Reason is why I am fit to be declared. Are fit to be declared is again a conclusion. It is not a finding. So, my lord, my submission is this order is also a non-est order. If all my points go, committee constituted, everything is there, deliberation is there, but this is not a reasoned order. Then, if your lordship will kindly see the next page again, page 32. So, the first resolution is they are fit to be declared. So, the minutes do not contain any record, any deliberation, analysis, finding. Second resolution is at page 32 to pass a reasoned order that the events of willful default were committed by the promoter, erstwhile directors. So, therefore, this is not the reasoned order. A reasoned order will follow. That reasoned order will also have to be seen, and that is the reasoned order which I showed your lordship. And that is signed by only 1 person. So, even these deliberations culminating in the reasoned order, the deliberations also do not contain any reason. This minute only show that X was authorized. Only show that a reasoned order had to be passed on the basis of the findings recorded here. No finding is recorded, so therefore nothing would have come. Then the last is the concerned CGM is authorized to sign the reasoned order. This is what has been followed. But the other resolutions are not given effect to. There is no order, there is no deliberation, only the signature is appearing on a purported document, which according to me cannot be an order in terms of 3C. So, these are my preliminary submissions on the identification committee order. If that order goes, this automatically goes. If that order stays even, there are additional grounds for challenging the last order.
Constitution, putting this document now
So, my lord, and my lord, I think, my lord, Mr. Mukherjee had also submitted some judgments. I will also rely upon that Atlantic judgment, my lord, which he had submitted, not only in relation to the constitution of the committee, but also to the fact that documents relied upon must be handed over and furnished to make a meaningful representation. Kindly see, if your lordship has that page number,
34.
Oh, delegation. I think, well, this question was shown to your lordship. The first question which was framed, it is page 11 of the judgment. Can the identification committee acting under the master circular for willful defaulters dated July 1, 2015 delegate its power to issue a show cause notice?
Page 34 of the judgment was
Yes,
placed.
my lord, page that is the answer is at page 34 of the judgment. And regarding, my lord, the documents must be handed over. Your lordship will kindly see. May I just place from last page 35, last 2 lines. If it cannot be delegated.
Yes.
If the functions noted above cannot be delegated, in my view, the requirement of issuance of show cause notice cannot also be delegated. The requirement must be discharged by the identification committee. Preparation of the minutes of its decision on the materials first placed before the identification committee in terms of the first portion of clause 3b of the master circular on willful defaulters will not permit the identification committee to delegate its functions of issuance of show cause notice based upon such minutes or its conclusion that an event of willful default has occurred on the strength of the materials placed by the bank before it. Clause 3b requires application of mind by the identification committee at all stages. It is required to apply its mind on the contents of the above show cause notice, as also it is a crucial stage in the whole process. Next line, my lord. Delinquent must have the entirety of the materials that were placed before the identification committee for the delinquent to give a meaningful submission. Right of oral hearing is not automatic. Therefore, it is imperative that the identification committee applies its mind to the contents of the show cause notice so the delinquent is not deprived of a meaningful opportunity to defend itself. This I am showing from their minutes, that 20th November 1st minutes, that, my lord, there was no deliberation which was recorded. It came to be recorded in the final order. But I could have understood deliberations are already there. One person is signing the order, reproducing those deliberations in the order. But this is not the case here, my lord. So, the other judgment has been cited. Developers, I am not citing that afresh, my lord. I am, my lord, I am also formally citing but not placing it because it has been cited. But I think, my lord, these are.
Yes. Who will? Yes. All right.
Lord, I'll tell you, Lordship, if your Lordship looks at the list. Now, well, the item number 3 is Biplab. Well, that is what Mr. Shakhoshen was addressing, your Lordship. Then, my Lord, item number 4 is Manoj Toshima. That is what, my Lord, I had submitted. I was led by Mr. Mukherjee. Then the next one is, my Lord, Ramesh Badia, and then is so allow me to, my Lord, it will be item number 5, which is Ramesh Badia. It is similar to item number 4.
All right.
Well, the only factual difference is that the petitioner had resigned as a director prior to the issuance of the show cause notice. This is the only distinguishing feature between item number 4 and 5. Apart from that, number 4 and 5 is otherwise the same. 4 was also a promoter and a director, but in item number 4, petitioner continued till the company went into insolvency. So, my lord, when the company went into moratorium under section 14 of the Insolvency and Bankruptcy Code, he was still on the board. So basically, he was one of the members of the suspended board of directors. But Ramesh had resigned. So Ramesh was not a director of the company, prior to the issuance of the show cause notice and when the matter went into CIRP. Well, this is the only factual difference. Apart from that, well, the challenges, so far as well, the constitution of the review committee, issuance of the show cause notice, no reasons, cannot be delegated. Well, they are the same as item number 4, which has been extensively submitted by Mr. Mukherjee was leading us in that matter. Well, this takes us to item number 6. Well, 6 is different, factually different also. But allow me to indicate what are the factual differences so far as 16 is item number 6 is concerned.
In item number 6, did you file a reply? It is not on record.
Oh, man, in court. Okay. না এটা আলাদা, পুলিশটা তো গ্যারেন্টর। So, the first difference so far as item number 4 and 5 is concerned, my lord, your lordship will find this is also an individual. My lord, she has been
4 and 5, but possibly 5 and 6.
No, 4 and 5 are the same. 4 was Mr. Mukherjee was leading us. That was the first matter that was argued before your lordship.
That's over.
4. So 5 and 4 are similar. Now, my lord, we are addressing
6.
your lordship on 6.
Right.
6 would be my lord Sunita.
Right.
My lord, Sunita, 6 was a guarantor. Now, she was issued the show cause notice along with the promoter directors and the principal borrower company in her capacity as a guarantor. So she was an individual guarantor. So, well, the test, so far as the master circular is concerned, so far as personal individual guarantors are concerned, well, are different from that of a corporate guarantor. Now, well, here, well, what had happened is our point before the committee was that the guarantee that she had given, the guarantee stood released. My lord, the lending to the principal borrower company for whose default the willful defaulter show cause notice was issued, my lord, was a consortium lending. My lord, the present bank was one of the members of the consortium lending. So, my lord, in the consortium lending, State Bank of India was the lead bank. So, my lord, in the joint lenders meeting, which is the consortium meetings, my lord, we will show your lordship one meeting. In that meeting, my lord, some of the securities given by the guarantor, the petitioner of your lordship, stood released, and her personal guarantee was also released. So she was discharged from her guarantee much prior to the issuance of the show cause notice. So, well, the question of issuance of the show cause notice upon the petitioner is without authority and jurisdiction. This was the point number 1. Well, in order to substantiate whether she was a guarantor at that relevant point of time or not, well, I just wish to rely upon one document. If your lordship kindly takes volume 2. Well, kindly take page 116 of volume 2.
Yes.
Well, when the show cause notice was issued to us, well, in terms of the circular and jar developers, we were entitled to give a representation. So this consortium meeting was a part of my reply. So they were otherwise apart from the fact this is their own document, they were otherwise obliged to take into consideration what I had stated in my representation referring to this consortium meeting, which has not been taken into consideration. That is what I wish to show your lordship. A, the fact that I stood discharged by this meeting. My lord, kindly take the minutes of the meeting which starts at page 116. Your lordship will find there are names of multiple banks in the box. But in the second row, the third name your lordship will find is IDBI Bank. Well, the fourth row, third name. Second row from the bottom.
Yes, yes.
IDBI.
IDBI Bank.
So, my lord, IDBI is the respondent bank which has issued the show cause.
All right.
Now, my lord, kindly now see the minutes of the working capital consortium meeting held on. My lord, kindly make a note of the date, 16th of June 2017. No, my lord, minutes is of... No. My lord, kindly see minutes of the working committee meeting held on 16th of June. So the meeting was held on 16th of June. Now, what transpired in the meeting, my lord, your lordship will kindly make a note. My lord, kindly come to page 117.
Yes.
My lord, your lordship will see list of participants.
Yes.
My lord, which includes, where is IDBI in the list of participants? My lord, all the consortium members. My lord, kindly take paragraph 6. IDBI kothay lekha. But my lord, kindly take page 119. Mr. Kedia further informed, paragraph 12 at page 119, para 12.
Yes.
Mr. Kedia further informed that all the lenders have agreed for substitution of flat number such and such at such and such with flats at such and such. So, well, there has been a substitution of the security which has been given in respect to the loan. Of all the banks has the new security structure, he accordingly requested lead bank to formally advise Allahabad Bank, who are holding all the mortgage securities and related documents, to release the documents of such and such. Which documents, my lord? Dover Lane flats are the flats whose security has been substituted. So that is one release because the security has been substituted. Then Mr. Behra clarified that as per the third supplemental working capital consortium agreement executed on 29th of September 2016, the said property such and such stands automatically released from the mortgage, and also the personal guarantee of Mrs. Sunita Badia and corporate guarantee of Loka Properties. So this was what was released. A, the security, the personal guarantee given by Sunita Badia, and the corporate guarantee given by another Loka Properties Private Limited. Now, my lord, kindly take I will just indicate, my lord. Kindly come to page 124.
Sunita Badia's guarantee was in respect of only one flat, the Doverland flat, and
no, but she had given a guarantee towards the debt.
All right.
Towards the debt, towards the exposure. So, my lord, once your guarantee is released, so you are discharged from the debt. So, section 128 of the Contract Act, by which a guarantor is jointly and severally liable, well, that principle would not be applicable. And the guarantor principle, my lord, is invoked under the master circular, and that is the only provision and by which under the master circular guarantor can be, well, lord, issued a show cause notice and declared as a willful defaulter, because the principal borrower has defaulted and the guarantor, having been called upon, has failed to make good the default of the principal borrower. So applying the principles of section 128, the guarantor is also liable to be declared as a willful defaulter. Now, my lord, kindly take page 124, which is the part of the minutes of the consortium meeting which I just placed. Your lordship will find at the top of page 124, this is the signature of IDBI Bank. So the release on the top of page 124, my lord, the attendance sheet starts at page 122. It starts at 122. Your lordship will see this is the presence of all the personnel representing the respective banks. So, my lord, IDBI cannot feign ignorance, so that I was unaware, I was not present. So this is the signature of the representatives, the authorized representatives of the bank who were there present in the consortium meeting. Page 124. Now, my lord, the identification committee's order. My lord, kindly have a look at the first committee's order, which starts at page 159. I'll just trouble your lordship with the relevant portions. And my lord, kindly come to page 165. Well, the order starts from 159. Well, the reasons or whatever is stated is at 161 onwards. Well, the submissions of Sunita Badia is recorded at 164. Now, my lord, kindly come to page 165. The bullet point from the bottom of the page, the second last bullet point from the bottom of the page at page 165.
Yes.
IDBI Bank never agreed to discharge Sunita Badia from her liabilities as guarantor for the credit facility availed by the bank, and that she has acknowledged the same by signing acceptance in the sanction letter of 20th October 2017. As an existing guarantor, her liabilities were coextensive, and the borrower and she continued to be jointly and severally liable for the facilities availed by the borrower. Now, my lord, kindly have a look at the document which has been appended by them to their affidavit in opposition. Well, kindly first take page 19. Your lordship will find the document of 18th October 2017. Well, this is the renewal of the credit facilities, yearly renewal of the credit facilities. 200 crores. Then, my lord, kindly turn to page 21. Your lordship will find a list of personal guarantors mentioned under the sanction of 2017. Because, my lord, she was discharged on 16th of June 2017. So, my lord, the sanction letter does not record her name as a personal guarantor. The others' name are recorded as a personal guarantor. However, my lord, the document that they refer to, my lord, your lordship will find that document at page 29. Well, their argument is twofold. A, they say that she has signed the sanction letter, and at page 29 they say there was an addendum on the basis of which her guarantee continues. Now, my lord, June, her guarantee has been discharged in the consortium lending. Now, in October, kindly have a look at the October letter. This is an addendum to the sanction letter. The sanction letter does not does not contemplate Sunita Bardia as a personal guarantor. There are 3 personal guarantors. I've shown your lordship that page 24. It does not contain her name. So by an addendum, this is what the bank has to say by way of an addendum. Kindly see the additional terms and conditions. So these are the additional terms and conditions sought to be added to the sanction terms, which is at page 21. Well, kindly see this. Kindly see paragraph 1. The personal guarantee of Sunita Bardia, well, kindly make a note of the language, to be furnished in addition to the existing guarantees as mentioned in point 1 Roman 8 of appendix 1. So well, the point 1 Roman 8 appendix 1 was page. Your lordship will find that at page 22. No, not at 22, my lord, 21. 21, your lordship will find there are 3 guarantors named. So, my lord, as per the appendix term sheet, which starts at page 22, the guarantors were required to execute document. Roman 8, your lordship will find is the security, which was required to be given. And your lordship will find at page 23, these are the documents which were required to be executed. And at page 23, the personal guarantees, there are 3 names which were mentioned at page 23 top.
Yes.
Yes. So what they are by the addendum, they say, so this has to be added to that terms. And the personal guarantee of Sunita Bardia to be furnished. So well, this guarantee has never been furnished after this. So in order to make up individual liable as a guarantor, there must exist a guarantee. So even assuming that this letter was issued, so there had to be a fresh guarantee which had to have been executed by Sunita Bardia. So there is no guarantee either on record or in law on the basis of which you could have held a personal guarantor, the petitioner before your lordship, jointly and severally liable. The addendum says to be furnished. So the moment you say to be furnished, so you accept the situation that there was no guarantee as on that date. So she was required to furnish it, but she did not. So in a connected proceeding, we've said here as well, in a connected proceeding, when the principal borrower was in CIRP, there is a proceeding under the Insolvency and Bankruptcy Code, which is section 95, by where the insolvency proceeding against personal guarantors can also be invoked. So the bank had invoked section 95 and initiated proceeding before the National Company Law Tribunal under section 95 against Sunita Bardia. Well, the procedure is that an interim resolution professional is appointed who has to file a report. So the interim resolution professional has filed a report saying that her guarantee is not there, she is to discharge. So the 95 proceeding should fail. Cannot proceed. So where is the authority and jurisdiction to proceed against a person who doesn't have a guarantee or who's not a guarantor? So in order to invoke, to initiate a proceeding, you have to be a guarantor. Otherwise, you cannot proceed against a person who's not a guarantor.
What happened to that proceeding?
Well, that proceeding, I think, is still pending.
Continuing.
Continuing. IRP has filed a report, so it has to be eventually dismissed. So, IRP files a report. The law is 195 is proceeding by operation of law. It is just a procedure. A interim resolution professional is appointed. That interim resolution professional files a report recommending admission or rejection. So the IRP has filed a report seeking rejection of the insolvency proceeding against Sunita Bardia as a personal guarantor of the principal borrower company who is in CIRP. So that proceeding, whether it will be rejected or not, that is pending before the NCLT. So my lord, all we say is that even a independent agency, a statutory body, or which has a color of a statutory flavor, this interim resolution professional, he's filed a report taking into consideration the discharge and has already put that in his report that there is no guarantee. Well, that recommendation is also there at page 94, which your lordship will find at volume 1. Well, your lordship will see it starts at page 81. If my lord looks at page 81, well, the recital at page 81, your lordship will send an application for initiation of insolvency process. Your lordship will see under section 95. Then your lordship will see IDBI Bank, which is the respondent bank here, and your lordship will find the name of the petitioner, Sunita Badia. Then, my lord, at page 83 is where the report starts. And, my lord, the consideration of the consortium meeting your lordship will page 85 at paragraph 7A. He considers, my lord, this consortium meeting of 16 June, which I have just placed before your lordship. And after taking into consideration all documents, the deed of guarantee, the alleged invocation, my lord, at page 92 is the observation made by the interim resolution professional. And the operative portion your lordship will find is at page 93. And at page 94, your lordship will see the recommendation. He says that the undersigned recommends rejection of the application against Sunita Badia. And, my lord, may I just draw your lordship attention to one paragraph, my lord, which I just placed, which is the defense of the bank. That letter, that addendum letter, my lord, kindly make a note of paragraph 7 at page 93. Based on the legal opinion received, mere signing on the addendum to the sanction letter without the execution of proper guarantee agreement do not constitute a valid guarantee. So there has to be a guarantee document on record in order to make me liable under section 120. There is none. I stood discharge in June. If you want to make me liable once again, or if there has to be continuation of my liability as a guarantor, there has to be some. Similar. Apart from this, my lord, if I may just trouble your lordship once with one clause of the master circular at page 195, my lord, it starts at page 188. My lord, kindly look at page 195. How a personal individual guarantor can be made liable under the circular. The last paragraph at page 195. In connection with the guarantors, in terms of section 128 of the Contract Act, the liability of the surety is coextensive with that of the principal debtor, unless it is otherwise provided by the contract. Therefore, when a default is made in making repayment of the principal debtor, the banker will be able to proceed against the guarantor's surety even without exhausting the remedies against the principal debtor. As such, when a banker has made a claim on the guarantor on account of default made by the principal debtor, the liability of the guarantor is immediate. Now, my lord, kindly make a note. My lord, this invocation was made when? This invocation was made against me in 2019. So when the principal borrower is in default, then only you call upon the personal guarantor under section 128. So this part of the master circular was invoked when? In 2019. That your lordship will find in the report of the which I just referred to. If your lordship kindly turns back, I'll just give your lordship the relevant paragraph. Just give me the relevant paragraph. My lord, at page 81, the interim resolution professional, he takes into consideration all the documents. There he has taken into consideration the invocation letter. So, my lord, unless you invoke a guarantee, you cannot sue the guarantor. So, under the Contract Act, to sue a guarantor for the default of the principal borrower, you have to invoke the guarantee. So, my lord, the invocation was made in 2019. Invocation paragraph. My lord, at page 85, my lord, I stand corrected, my lord. I said 19, it is 18, 24th of October 2018. That your lordship will find clause D at page 85 of the report. So it's a question of fact that it was their letter which was invoked. By that letter, they invoked the guarantee which was not in existence at para D at page 85. Your lordship will find the date. It says the personal guarantor also
85
of the writ petition.
Of the writ petition.
Of the writ petition, which is a part of the report of the interim resolution professional filed before the NCLT Kolkata in relation to the section 95 proceeding.
D. Personal
Para D.
guarantee.
Para D.
Notice of invocation.
Personal guarantor also stated that the notice for invocation of the personal guarantee dated such and such referred to the deed of guarantee of 2016 only, which was already released pursuant to the resolution passed in the consortium members meeting dated such and such. Well, two things emerges from this. So the invocation letter is that of the bank. Is the invocation letter on record? Just give me the page number. Well, two things emerges. You have invoked which guarantee? You have invoked the guarantee of dated, my lord, kindly make a note of the date, my lord, 7th of October 2016. So, my lord, this presupposes the fact that there has been no guarantee after October 16. Because if there was a guarantee given by me pursuant to the addendum letter of October 2017, so you could have invoked or you would have invoked the guarantee given in 2017, but your invocation letter refers to the guarantee of 2016. This 2016 guarantee stood released admittedly on 16th June 2017. So when you invoked in 2018, October 2018, what you invoked was the guarantee of 16, which was not in subsistence and stood released. So the master circular, page 195 of the master circular, well, there's a violation or there is a, well, their action to proceed against this guarantor is contrary to the master circular. Because the master circular says the triggering mechanism is when you call upon default by the principal borrower, you call upon the guarantor defaults, you can thereafter proceed against him to qualify and declare him as a willful defaulter. In case the guarantor refuses to comply with the demand made by the creditor, despite having sufficient means, so the two tests. A, you have to call upon. So if I don't have the sufficient means, even then the guarantee or at least the classification of willful defaulter proceeding will not. You may recover. You may proceed to recover. but you have to satisfy the test laid down in the master circular. A, that there was an existence of a guarantee. So there was a default by the principal borrower. Because of the default of the principal borrower, I have called upon you as a guarantor. Once called upon, you have failed. Now, after you have failed, you have sufficient means to satisfy the default. Despite having means, you haven't satisfied. So you are entitled to be declared as a willful defaulter. So, my lord, none of the tests laid down in the master circular has been complied with. And my lord, last but not the least is the point which we have taken in the other writ petitions as well. My lord, that is the composition of the review committee, as your lordship has already seen.
All right. Now, this is with regard to Sunita.
This
Then
is regard to Sunita, which is my lord, item number 6 in your lordship's list.
Right. Then 7 and 8.
7 and 8,
Right.
my lord.
Will the submissions differ?
My lord, I will only address only on the points where I differ, because I think I have a case better than those which have already been argued. Because in 7, the primary argument which I would make is that the show cause notice was not served, but the order was passed before that.
I'll hear you on the next day, not today. এগুলো কি সব একসাথে অর্ডার করছে? বলা আছে একসাথে শুনানি হবে?
পরের বৃহস্পতিবার আসবে না? ইন্টারিম অর্ডার চলছে তো, যা হোক শেষ করে পরের বৃহস্পতিবার তো আমার
আচ্ছা, তারপর 4 নম্বরটা করুন, কবে রিটার্নেবল পরে বলছি। 4 নম্বরেও সেম সাবমিশন
উত্তর দিই তারপরে
অফ দ্য পিটিশনার। 5 নম্বরেও তাই, 6 নম্বরেও তাই, 7 when do I keep it next?
My lord, can I pray for 15th? My lord, next week I am in some difficulty, my lord, personally. If lordship permits me to come back on 15th, I'll complete on that day itself.
Because till you complete,
Mr.
I will-
Chaudhary can't
yes,
start. Yes,
the
my lord, I will
respondents
complete
cannot.
that day, and I am sure, my lord, Mr. Chaudhary will get time to even start that day.
Let us see. Do not preempt that way. 7 list for hearing on 15th.
Only because
And
there are factual differences, my lord.
8,
8 also I am appearing, my lord.
ঠিক আছে, same 15th. আগের গুলোতে তাহলে list for further hearing on 15th.
My lord, in item 6, my lord, there was an affidavit in reply which was filed.
Yes, 6 er affidavit and reply filed in court today is taken on record.
My lord, the interim orders are till, in 3 matters till 15th. कौन-कौन matter है बोलो? My lord, in item 7 and 8. আমাদের গুলো তো 3, 7, 8. My lord, in items 3, 7 and 8, the interim order is till 15th, my lord.
When was the interim order passed?
I'll just give your lordship the date.
Shall be restrained from publishing the photographs of the petitioners pursuant to the declaration.
indicative violations.
2nd of July. was
July.
There is no date.
2nd of July was the, my lord, order,
2nd July.
and it was extended, my lord, thereafter.
What is the interim order? Not to publish? the
Not to
photos?
publish, yes.
Lord, I have, in one of the matters, Sundarlal Dugar, there is an order of 30th July of Justice Sarkar, Justice Shampa Sarkar.
Sundarlal Dugar is item 8, my lord.
I can see Justice Bhattacharya's orders on 24th of May 2024. During pendency of the writ petition, the respondents shall be restrained from publishing photographs.
That is the nature of the interim order.
So if that is continuing, then it can continue.
That is what.
There is no date mentioned. during pendency of the writ. That means till the disposal.
My lord, that is in 3 matters. In the other 3 matters which I was talking about, my lord, items 3, 7 and 8. If your lordship kindly takes, my lord, one of the orders, it was
Let
time bound.
me listen.
Lord,
Are you publishing
I
photographs or
don't think,
anything?
my lord, lordship can record, my lord, I have no problem. Because still this lordship is already hearing the matters.
Yes.
It has not been published till now. It is unlikely to be published, my lord. We won't take advantage of the fact that technically some has expired and that.
No,
Because
it has not expired. I do not know whether IDBI, MK and
My lord, MKN, Sundarlal and my lord Viplab Bose, items 3, 7 and 8. The language of the order is bank shall not take any coercive measure on the basis of the decision. It's not restricted to, my lord, publication of photograph. And it was, my lord, time bound if lordship sees. That's the reason why, my lord.
yes, in that matter it was time bound. I see.
And
MKN,
lordship's
but
order is
others-
there, my lord. At least in MKN, we know 12th of March, lordship had extended it till 31st of July. So we are covered, my lord, till 31st of July.
All right.
We are covered.
So no further recording today. Next day, let us see.
Grateful, my lord.
520 সাথে রাখুন তো।
আপনি যাবেন না?
No further matters.
ब्लड साइड का बोल रहा है before my lord calls the list, my lord, we have just been, my lord, the notification has been uploaded that, my lord, your lordship has the urgent determination pertaining to, my lord, the determination of my lord Justice Tirthankar Ghosh.
For
My
a
lord,
day only.
My lord, the difficulty is, my lord, today my matter was fixed as a leave matter at item number 1. My lord, there is extreme urgency in the matter. My lord, I am a lady, my lord, who is, my lord, running from one place to another. My lord, the so-called husband and the in-laws are, my lord, Bangladeshi citizens. My lord, we have got the, my lord, the basic documents, if lordship is so kind to kindly.
So what is to be done today?
My lord, the difficulty is, my lord, I am under the threat of life. My lord, the police is not taking any steps.
One day. The determination is only for a day. Tomorrow, please go. Otherwise, file will come, file will go. It become difficult. It's better you get the matter heard tomorrow.
Mention a contempt application for non-prosecution, my lord.
Which
From
determination?
your determination.
Is this the time to mention?
Yes, my lord.
Is this the time to mention? Who has sent you?
Appellate side mentioning that.
Who has sent you?
Senior, my senior.
Senior? Consult with your senior and then mention. Yes, call the list.
Lordship, item number 1, we're appealing for the customs authority. Lordship, correction is lordship only for cost title. Lordship, this correct cost title is lordship only the fibers private limited and another versus Union of India and others. Lordship, order was passed 13 June. Lordship, wrong.
Yes, yes. Ashwin.
My lord, I'm for the petitioner, my lord.
It a Union of
Lord, my
India,
application
State of
for
West
restoration
Bengal.
is also pending here, my lord. It's appearing in the today's list, my lord.
If it is dismissed, it's dismissed.
Yes, Lordship.
Lord, my application is filed, my lord.
It is pending, it will remain pending.
The list, my lord.
It is there in the list, it will be taken up.
Well, it is listed today only.
What do you propose?
My lord, may I only pray for the restoration of the
As and when it is called on. Next.
lordship is only.
This matter is coming at my behest, will it?
Yes.
Will it passed an order on 26th of June 2024, 2025. Will it? Pursuant to
26.
in that order, what has gone on is that the contract of the petitioner with regard to it, this writ petition had two aspects. One dies on, and the other was with regards to trolleys, where the trolleys period is extended. But all that I propose, subject to my learned friends, that has been desirous of sending this matter to be considered by the railway divisional manager. All that I propose that the first paragraph, maybe this much be included, Millet. But it is an admitted fact that the writ petition had two aspects. We will kindly see the first order, the 25th June 2024, by which the
No, but then when the matter was placed,
so this
this submission was made.
no, yes, it was made. And while I had before coming to mention it, I had checked the live streaming.
Yes.
It was mentioned that the trolleys are extended. Trolley period is not expired. Only that much that I was seeking for inclusion of.
Where is the extension?
We'll see. We'll see page the last order also. The first order of 26 of 25th June 2024, paragraph 6. We'll see this.
10.
The candidate.
Paragraph 6.
Yes, Milord. By a communication, which is at page 14 of the writ petition, the contractual period for trolleys and tables were revised, and the contract period in respect of trolleys were reduced. This was contrary to the communication. That is all that I am beseeching to be recorded, Milord. That this, while dealing with dies on all only, the other aspect would not be taken care of by the divisional manager. So we'll see the proposal which I have made in my in the correction that I'm seeking. I'm only seeking,
No. 1 minute. The paragraph 6 you read out.
Yes, that is at page 48 of my writ petition.
48. The contractual period for trolleys and tables were revised, and the contract period in respect of the trolleys tables were reduced.
Yes, Lord. The trolleys were converted as MPS in 2022 for a period of 5 years. That would have expired in 2027. By a letter of 22nd May, what they have done in effect is that they are saying since the stalls are getting expired by such and such a date, so with the trolleys. So that is contrary to the Railway Board circular and the clarifications, Lord. We'll see page 48.
Yes.
First one is stall, second one is stall. The third one is trolley, 4 trolleys.
Yes.
That is operating period was 22 to 27. Then we'll see to be read as operational
from 22 to 24.
Yes, Milord. That is what, Milord, is incorrect and contrary to the Railway Board circular and with the circular and the clarification.
But the submission was not properly made.
Yes,
you were not there on the day when the order was passed.
I checked the live streaming. It was succinctly made, but not it was very subtly made, but not impressing on this aspect.
And not only that, when the order was recorded, also this was not placed.
Yes, that is the reason why this is the only. We'll see the correction that I'm seeking for is only the facts, nothing else. That I do not mind going before the commissioner, before the divisional commercial manager. This is only my contention, Milord.
The instance of the learned advocate representing the petitioner. Stop. It has been submitted that one very vital fact has missed out from the in the order dated 26th June 2025. Stop. The petitioner refers to page 48 of the writ petition to show that the period of contract in respect of the multi-purpose trolley stood reduced. And the same is contrary to the Railway Board circular. Acha. the following paragraph will be added after paragraph 5 of the order dated 26th June 2025. At the time of consideration of the petitioner's representation, at the time of consideration of the case of the petitioner, comma, the authority shall take into consideration the issue of reduction of the contractual period for the multipurpose trolleys, along with the issue of the dies non period.
I'm deeply obliged. I'm very sorry for that. I was before some other bench.
Very well.
I'm obliged. Deeply obliged.
Rest of the order remains the same. Let this order be read along with the order dated such and such. Yes, next.
Adjournment, Lordship, I am for the petitioner, the matter for the non-prosecution lawsuit.
I am for the private disbarment.
Like, thanks.
Why non-prosecution?
Lordship, I don't know, Lordship, the client said he doesn't want to proceed the matter, Lordship.
Already yesterday the matter is dismissed, my lord.
Dismissed?
Yes, my lord. Item number,
Nothing doing. Dismissed. Stay looking good.
I have no Lordship, I just.
the matter is dismissed yesterday.
না না আমার সাথে প্রদীপের কোনো কথা হয়নি
না
nothing to be recorded. Take this back. কালকে dismiss হয়ে গেছে আজ হ্যাঁ
646 item.
The matter has already been dismissed
674.
for default on 2nd July. Stop. No further order is required to be passed in the writ petition.
My lord, core is appearing at my instance, my lord. There are some formal defects in the writ petition. I'm seeking leave to withdraw with liberty to file afresh, my lord. My lord, RDSO has been made a party. It's against the Metro Railways. RDSO has been made a party, my lord. It's not necessary. And two responsible officers.
Incurable defects dismissed. Leave to file
Leave
fresh.
to file fresh, my lord. I'm grateful, my lord.
না 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 চার চার
আমি
Five, my lord, for my before my learner's start, my lord, petition, my lord, I am representing some of the students. Although there is no application as of today, my lord, I'm saying I want to intervene in this matter since I am against the prayer of the writ petitioner. My lord, kindly grant me some liberty to file an application and come before your lordship and place the records before your lordship. Whether
No liberty. If you want to file an application, you are open.
I
You
will
can
file,
always file.
Therefore, my prayer before your lordship, my lord, may not pass any order to the. And
Let me know what the matter is about. Who is for the petitioner?
Your Lordship, I am for the petitioner.
What is the matter?
Leading, Mr. Shamim Ahmed is leading me. The petition is about issuance of the EWS certificate in the state level, annexure C certificate.
Yes,
Yeah.
you were supposed to take instruction possibly. What happened?
My lord, regarding my lord, portal, my lord, we can update it. My lord, there is no difficulty. The problem is, my lord, there are certain criteria before issuing the AW certificate. My lord, we have to conduct an inquiry whether he is fulfilling those criteria or not.
Who is
After-
stopping you?
Yes, my lord, after obtaining those reports, my lord, then and then only, my lord, we can issue, my lord.
Yes.
We have to comply certain formalities. So to that effect, your lordship earlier also passed an order directing the authorities to take decision in this regard. If your lordship
Yes.
passed similar type of order, we have no objection. We shall conduct an inquiry whether he is fulfilling the criteria or not. If he fulfills the criteria, then we can issue the.
Obviously, if a candidate does not fulfill the criteria, there is no question of issuing a certificate. That goes without saying. But why are you not doing it? This is the question.
Because our system, because he, while making application, he project himself as subcaste Khandekar. In our state list, Khandekar is the OBC candidate. The object in the whole scheme was a candidate only obtained EWS certificate if he does not belong to the SC, ST or OBC category. Since our system is showing he belongs to OBC category, but we cannot proceed. That was the my earlier submission also, my lord.
So now you have changed.
We can change the system, subject to the compliance of all other formalities as stipulated in the scheme.
For changing your system, what is the formality?
No, for not changing. For whether he is fulfilling the criteria or not,
That
as
is
stipulated
different.
in the guidelines.
That is different.
But there is a serious issue, Millet. People are not being able to, Millet, submit their application, Millet, because of these technical difficulties.
How soon will you update yourself?
Regarding this issue,
this issue at large, because the people.
This is not restricted only to the petitioner. There may be several other candidates. Not restricted to the petitioner. When will you update yourself?
Yes, dear Lordship's order, earlier order, can you see?
No, I have my order over here. Why will you show it to me?
Similar matters, what order your Lordship have passed, that I am submitting,
What is the order?
Can you see?
Not in this matter.
Identical issue.
Identical issue, yes.
Identical issue may not be.
This is, how can you say this is identical? This is regarding relaxation of the eligibility criteria. He doesn't want any relaxation.
Issuance of EW certificate. Can you see?
There is a difference. This is a relaxation of the eligibility criteria. He doesn't want any relaxation. You are getting things wrong, misdirecting yourself.
Regarding this issue, regarding petitioner's case,
Not the petitioner's, don't take it as a petitioner's case. You take it as a general case meant for everybody. EWR certificate has nothing to do with the reservation. EWR is a different section altogether. Economically weaker section. It may be from the general caste category also. Are you not issuing EWR to general caste candidates?
Can you see the scheme? What is the scheme once? Can you see the scheme, please? Can you see?
Let us see the constitutional framework. What was the constitution?
Which page is the scheme?
Page Annexure 1. Can you see?
Annexure 1 is a report in connection.
Memorandum, my lord.
Where
Page
is
3.
the memorandum? Yes, memorandum.
Yes,
18th of May 23.
Nomenclature, can you see?
Yes.
Economically weaker section is a term that describes the persons who are not covered on the scheme of reservation for scheduled castes, scheduled tribes, and other backward class with income and assets below the criteria as set by the government. EWS certificate is the proof that a person belongs to EWS category and is eligible to avail the reservation benefits meant for the EWS. Yes. So the main criteria is a candidate who belongs to SC, ST, or OBC. He cannot apply for EWS certificate. That is the whole scheme.
I didn't get it. A candidate who
belongs to SC, ST, and OBC. He cannot apply for EWS certificate as a general category candidate. Only the general category candidate can apply for EWS certificate because that is the double benefit. That is the double benefit.
They cannot have the both facilities.
Yes.
What is the facility he is wanting?
Reservation facilities and EWS facilities.
No, he doesn't want reservation.
That scheme, our scheme was framed. Our scheme was framed that.
Counseling, NEET UG counseling. Thereafter, they will be enjoying.
Enjoying what?
Actually,
after 1 year, they may claim for his because this EWS certificate is valid for only 1 year.
Yes.
After 1 year, they again claim for the reservation benefit.
They will cross the counseling.
Well, they cannot claim the double benefit every time.
Are they opposing this? Let them file it on affidavit. will expose
That's
this.
why before that, my lord, you start, my lord,
Object of a
was praying-
statute and the constitutional
Need to
scheme
find
will
out
be
what
frustrated
you
by the
do.
mistake.
Since the matter has been taken up, your lordship, that's why I'm saying, my sometimes.
Yes,
If
please.
that is the statement, let
One
me
minute.
My lord, certain instructions
let it
are
be clear.
given in the information
Who's
bulletin.
begun it? Hello.
My lord, the candidate should possess EWS certificate. My lord, what happened, my
Application
lord,
may
at the
be
time of making application online, they need not upload the certificate, but they have to obtain it later. Now they have to mention the category. What is category they belong to in the application in their documentary. Then there is a suppose there is a change of category. Now then there is a window. My lord, window is opened. It was opened on 9th March for 2 days. Then anybody they can change the category. Now, my lord, the result came out, my lord, on 14th June. Now, in the meantime, they are seeking, my lord, the category rank has been declared. It has already been announced. Now, they cannot, otherwise it will upset the whole system. My lord, once the category's rank is, my lord, declared, my lord, there will be difficulty. My lord, they have to obtain, they can very well, if they are eligible for this EWS certificate, they can appear, they can submit it before the counseling committee. But at the same time, there is some difficulty with regard to the ranking.
Sir, I have not made any prayer against your authority. First, second,
Thing is,
we have applied under EWS.
Thing is, 1 minute, let me understand. You have been declared successful.
Yes.
In
EWS category.
Very well.
My application was under EWS category.
Right. Now you simply want the certificate.
Yes.
You do not want change in your ranking.
Nothing,
So
nothing,
it doesn't have anything to do.
No, but some of the candidates who are, my lord, seeking to
Trying to mislead the court.
They applied under general category.
They all apply under general category.
General category, general EWS, they have to mention. Not general. If it is general, then it's.
Oh, I see. General EWS.
That should kindly take their supplement, the application for improvement. There, some of these candidates have applied under the category of general and not
the EWS.
Under basic. I
Yes.
can find out.
Yeah, that I get it. That I understand.
My lord, they have applied. All of them have applied after March, April.
They will not get a facility over there. It's
Kindly
as
take some
simple as
page
this.
21 of my petition. Page 21 of my petition.
Some have applied on 23rd June.
Sir, let me clear.
Result came up on 14th June.
All right, let me.
Page 21 of my petition.
Yes.
Now, this is the rank card.
This is the rank
card, scorecard.
Scorecard. Admit card
In the
provision.
middle millet category, general EWS. And my
Where there is general EWS, it is all right. There may be candidates where it is mentioned only general. You cannot add EWS then.
Certainly not. Unless I apply.
It is separate.
Application, my lord, I'll point out the pages, my lord.
But that does not preclude me to apply for EWS certificate.
That is different.
That's not the application for improvement. For instance.
For page 13.
Page 13.
Hmm.
He applied for EWS certificate on 23rd June 25 under caste general.
Are you referring to this page? Page 13?
The
Application, possibly intervention application.
For intervention.
There is an intervention application, possibly.
Intervention.
Yes.
That was filed on the last one.
Similar other candidates.
What is the number? Can
Number is blank, my lord.
First be the last one of your lordship's file.
It was
3.
shout upon me on
Last,
last page.
the file in the bottom left.
Can one? 1 minute.
Net nahi to.
Page 13.
But
Page 13 is the acknowledgement slip.
Yes.
Yes.
He applied for EWS certificate on 23rd June.
Yes.
Then under caste general.
Right.
To the next page.
Yes.
Category general. At the middle.
Category.
General. At the middle portion. Category.
Yes, category general.
Yes. Now he's applying for my lord EWS certificate and he claims to. My lord, like
Well, he'll not be treated as EWS.
With the issue involved in this petition.
He will be treated as general candidate. It's as simple as this. That is your stand. It's all right. But thing is, whether EWS certificate can only be restricted to the scheduled caste, scheduled tribes, and OBCs.
There is a provision, my lord, because they are not entitled. Because 10% is reserved for EWS. 10%. But for SC and ST, my lord, it is not reserved. My lord, lordship.
Listen, this EWS certificate is valid only for a period of 1 year,
1 year.
right?
Yes.
And thereafter, the economic condition of the candidate may develop. It may go down also.
Unlike PW,
Yes, physical is something different. So EWS is not necessary only a scheduled caste candidate or a OBC candidate will be a EWS. General category candidate can also come from an economically weaker section, isn't it?
Only one thing, my lord.
There are already criminal and non-criminal divisions there.
Claims.
No, his claim, I will not link it with you. He may use this certificate for a period of 1 year for other examinations also. So it is not related to you only. Yes. State.
My lord, kindly not take a reservation. ST 15%.
No, I'll not go to that. That is not the issue. I'll not.
আমি কিছু তো রাখছি ওই ক্রাইটেরিয়া একটা বলতাম করতে বলে দ্যাট মিন্স ইউ
কি ক্রাইটেরিয়া
হুম
কি ক্রাইটেরিয়া
অনেক ক্রাইটেরিয়া আছে ইডব্লিউএস পেতে গেলে কি কি
The memorandum that you placed,
মাই লর্ড
18th of May 2023.
ইয়েস মাই
It starts with a subject mentioning modification in the guidelines.
Yes.
What is the original one?
original guidelines মানে please মালাট annexer 3 annexer 3 মালাট can you see
Yes, reservation of EWS in such and such.
even modification 18th is also the modification. It was initially on 9th July 2019.
clearly stated not covered under the SC, ST and OBC reservations.
Right. They do not claim themselves to be covered by SC, ST, OBC. They do not claim. So they will be covered by this.
Today they are saying,
amendment আছে
but after few days they may claim in respect of another employment.
Is there a bar? Economically weaker section is meant for a year depending upon the economic condition of the candidate.
My lord.
You go inquire, see whether he is falls within the economically weaker sections or not, and then you proceed.
Very well. Our candidate we shall proceed to in respect of the petitioner's case.
Why in respect of the petitioner's case? It will be meant for everybody. Anybody who
Of others,
court was not come
we
to
have
court.
we have department have already instructed the competent authority to modify the portal.
Yes,
It will take some time. So for the petitioners in concern, we shall process for issuing certificate if he fulfills the criteria.
Delay will ultimately increase the number of cases. Kindly take some of the constitution vis-a-vis there.
No, listen. They have agreed to upgrade.
To the extent that even if you have the reservation, you can apply for it.
To the extent?
Even if your caste, subcaste is appearing in the list, you can apply for reservation. You cannot take the advantage of both together.
Yes. EWS is an absolutely separate class.
Absolutely.
Not related with,
in addition.
Not related with general, not related with OBCs. It is meant for anybody who belongs to the economically weaker section.
That's all. Kindly clarify
Now,
this and kindly come.
Whether you will get a chance in this year or when year, which year?
That's not the issue.
Not the issue.
Let them file a report to the extent that they have considered it. Otherwise, I have to come again.
I'm not disposing of. I'll wait till they upload it. Please come. Learned advocate representing the state respondent submits that the department will take necessary steps to upgrade the portal for issuance of economically weaker section card, EWS card, irrespective of the fact whether the candidate belongs to the other reserved caste or to the general caste. Stop paragraph. EWS is EWS certificate may be obtained by any candidate who falls within the economically weaker section bracket. How soon?
2 weeks.
List on 17th.
In the meantime, let them consider our applications.
They will consider.
I may help
Then, my lordship can pass order, inspector, petitioner, whether
petitioner and other applicants.
See, restricting it to the petitioner may not be proper because this is for everybody. This is for everybody.
keeping the matter pending, my lord.
I am keeping the matter pending. You take steps. The court is not stopping you.
My lord, kindly, my lord.
Yes.
Unless there will be difficulties, my lord. Kindly,
What is the difficulty?
Kindly pass.
What's the difficulty?
Pending applications.
What is the difficulty? I cannot understand the difficulty.
My lord, kindly add one line. During the pendency of the, then kindly pass during the pendency, authority will not be precluded for processing the petitioner's application.
Petition, all applications pending.
What you are doing, you are increasing matters. There may be several other candidates like the petitioners. You take steps. The moment you upgrade.
Yes, my lord. After upgradation of the portal, my lord, everybody will be allowed, my lord, to make application, my lord.
Yes. So you proceed. Yes, call the next one.
Item number 6.
Okay.
Item number 6.
My petitioner.
Yes. Union of India. You are for the Union of India? What is the matter?
For the respondent bank.
Only things needs to be decided, Millet, whether Millet, the notice issued by the bank in respect of a loan is at all Millet, secured interest or not. But if it is not Millet, then 2002 Act has no manner of application. But if they files a report saying that yes, they have Millet with them the title deeds and it's a secured interest, Millet, then I have no case. Because the scope of writ jurisdiction is very limited. I have said that this is without jurisdiction. Since this 2002 Act has no application, it is the...
Who took the loan?
But I have never. That's the reason that I have come. I never signed. I have never taken any loan. My name is not appearing.
Where is the notice? How are you aggrieved?
Because my property is being attached. My property yesterday, they have put a padlock. Yes, I have stated that I have got information from my brothers. They have taken loan.
Is it a joint property?
It's a joint property, but it is not a mortgage. It was not mortgage ever. Unless the land is given to them, how come this 2002 applies? Let them file a 2 lines report that yes, it's a mortgage by the deposit of title deed. I have no case. I'll be out.
I'm applying for the respondent bank in this matter.
Yeah, I understand. But then, who are your brothers? Private respondents?
Private respondents.
How is your relationship with them?
But they reside separately, not with me. That's the whole difficulty. And I have annexed the page of Sarsai, where the names of the borrower and the guarantors appears. Even there, my name is not appearing. At page 35, it ends at page 35.
Yes, page 30, it starts. The names of the borrower. Borrower type is individual.
It starts
Asset category is immovable.
30 onwards. My name is not appearing.
Immovable residential, immovable square feet. What is your submission?
Lordship, this is the paper book which has been filed before the Landed Debt Recovery Tribunal
By whom?
by bank.
All
In
right.
respect to the petitioner herein also, he is the borrower. Lordship, kindly first.
Petitioner is also the borrower?
Yes, Lordship. I will show you, Lordship. There is, the petitioner has not come before you, Lordship, in clean hands. Your Lordship, kindly come to the page 45. Running page 45.
Let me see whether the petitioner is the
Yes,
party
yes,
over there or
yes,
not.
Your Lordship. Kindly come to the post title, which is in the page 2, Your Lordship.
Petitioner is Vishwajit De.
Your Lordship, the page.
Particulars of the defendants is Vishwajit De. This is Andhra Bank.
Yes, now it has been merged with the Union Bank of India.
All right.
Previously, it was with Andhra Bank.
And Shurajit, Vishwajit, Abhijit.
I was never
Both.
served with
Both.
anything.
This is a original application of 2020.
Yes, Your Lordship.
Right?
Yes, Lordship.
And
Then
was the
deed.
petitioner appearing in this matter? Did
He
the
has been
petitioner
served. This
ever?
is the summon copy, Your Lordship, issued by the Debt Recovery Tribunal. He has been served. Your Lordship will see the scheduled property has already been injuncted by the Learned Debt Recovery Tribunal in 2022 itself. The summon copy, the original, the summon copy is there, Your Lordship. I have the original copy also, in which the Learned Debt Recovery during the time of admission was pleased to injunct the said property, and it has been served upon them on 2022 itself.
And is it your case that the petitioner is also the borrower?
Yes, Your Lordship. Kindly come to page 45 once. I will satisfy Your Lordship. Kindly come to page 45.
Yes, please.
This is the document which shows the mortgage deed has been the deed has been mortgaged with the bank. Your Lordship, the signature of Vishwajit De is in the below, Your Lordship.
In respect of which account?
In the same, in respect to the same mortgage deed which they are challenging in the writ petition is been mortgaged. The deed is also annexed after that. Your Lordship, kindly come to page 47.
Yes. What
Same
is
deed,
the
Your Lordship.
description?
Same
What
deed,
is
Your
the
Lordship.
description? Give deed number.
Your Lordship, kindly come page 20 of the writ petition.
Yes, 20 of the writ petition.
And page 47 of the my paper book. 26, 20, page 20. Page 2.
Yes, it is the same document. Everything is there.
Your Lordship, they are
Let them file a 2 line.
No, I will go-
Their case is, I believe that their case is, this is a mortgage by deposit of title deed. It is their case. They cannot deny it. Let them say this on affidavit that this is their case.
I'm showing it.
I cannot submit to a wrong jurisdiction. Even if I have made a
You have already applied. Your signature is there in the loan
not
document.
my signature. Can't be. I have said on affidavit. And I say that the deed is with me. How can I say that the deed is with them?
Your Lordship, this is not the only one document. These are
Let them produce the original deed. I'll expect a huge cost from this court. Let them produce the deed from before the court. Well, if it is
at the time of taking loan,
yes,
you all submit to their jurisdiction, and when at the time of recovery, now all types of stories
at the
come
time
up.
of taking loan, if it's a secured asset, they have the deed with them. They must have. But I tell you, what has happened, Indeed, I had taken loan from the bank, not from the Andhra bank, from this bank, before its merger. Now, they know my signatures, they know my everything. I have repaid the entire loan. I have pleaded in my petition. Repaid the entire loan. They have handed over the title deed. Now, Andhra is now merged with this bank. Now, now taking advantage of this, they must have procured my signature.
Not one series of papers are here.
I have on oath said that I have never executed any document with Andhra. I have never taken loan from Andhra. I have the title deed is with me. If they say that it's a case of 2002 Act, let them say 2 lines before the court. I have said on oath. Let them say this, and your lordship impose the cost. I'm inviting it. But authority, they are acting in terms of the statute. They cannot take advantage. They cannot play fraud on statute. Their license should be cancelled, my lord. Or I'll be inviting my lord cost.
And who is playing fraud is to be seen.
Yes, your lord.
That can be ascertained if they can produce. The bank must be with them the title deed. Let them produce it before the court. Because they have applied 2002 Act. They have issued notice under surface.
Do you have the title deeds?
Yes, your lordship. The title deed has been verified. The original has been verified by the learned DRT as well. We have the title deed. Your lordship, now I will show the conduct of the petitioner.
Yes.
Now, your lordship, kindly come. What they're doing, your lordship, they have portrayed before lordship a different loan account. This is not the loan which has been, which they are saying that they have settled. Your lordship, this loan has been given by a different branch when the merger has not into existence, your lordship. And this is a different bank. My Andhra Bank now merged with Union Bank, but previously it was not. So lordship will find out both the deeds are, if they're saying that they have the original deed. So now they have mortgaged the deed with the Andhra Bank as well. At the same point of time, how a person can take the loan from two banks by the same deed. So the fraud has been done by the petitioner itself. Now, if the petitioner today say that they have not done so, then a criminal investigation should have been done against the petitioner as well. So how the deeds are being mortgaged? Lordship, this is the fraud the petitioner is not doing.
Cat has come from the back.
Show me the order of injunction.
Your lordship,
Must
kindly
be
come to
there.
the summon. Your lordship, I have given a one-page document.
Yes, this
Summon,
cover
in the
is-
summon, it is written on the
Yes.
page 3. You are restricted from dealing with or disposing of secured assets or such other assets and properties disclosed under serial 3A of the original application pending hearing and disposal of the application for attachment of properties. Now, what is 3A, your lordship? My 3A is given in the paper book, which is in page 112, your lordship. This is the scheduled property which is mortgaged, and this is the and which has been derived from the title deed itself. If and your lordship, once or last submission, till date they have not disputed this fact before the learned DRT. After
I have never
getting the
served to
summons.
it.
Now you got to know that the matter is.
Milord, no, Milord, kindly hear me,
Oh,
Milord.
sorry.
Milord, I
You
cannot
go there.
submit to a wrong jurisdiction, Milord. Milord, they have not initiated a case under section service, Milord.
You
I cannot submit to a wrong jurisdiction. If
go and make submission over there, then
how come Milord, the
they
court,
have invoked jurisdiction
the
wrongly.
court has invoked jurisdiction which has no jurisdiction, Milord.
You have to intimate the court. The court doesn't know about it.
Milord, that's I have not been. First of all, Milord, I cannot go to the court which has no jurisdiction. Rather, I have to go to the court which has jurisdiction, saying that that court has exercised jurisdiction.
Sir, the court does not know that it is exercising jurisdiction wrongly.
Milord, that is
you
not.
are to intimate.
Is it my duty, Milord, to?
The court, the summons has been served upon you.
No, I have never received it.
The
Milord, before that, Milord, Milord, kindly, Milord, may I pray for this, Milord? I do not pray for any injunction. All that I'm praying for.
Already injuncted.
No.
Question
All that I'm
further
praying
prayer.
for. All that I'm praying for, that to ascertain whether it's a secured credit or not. That is my case. Let them say one line on affidavit saying that they have with the title deeds, because but that is the case I have made out. Milord,
I'll keep the paper book on record.
Yes.
And say that the matter is pending over there.
this
and
paper book,
a secured
Milord, this
asset.
paper book is not affirmed.
It
At
is
least before,
affirmed
not before this court. The document is being submitted before the court is not an affirmed document. Let them annex this and file an affidavit, one line, saying that yes, they have this with them. I'll go there. I'll go to the tribunal. Let them file an affidavit.
The petitioner alleges that the bank has exercised jurisdiction wrongly under the Surface Act and sought to take steps against a property which is not mortgaged to the bank. Stop. Learned advocate for the petitioner insists that
And the title is
original title deed of the subject property is with the petitioner and the property is not a secured asset. Stop. Next. The prayer has been made to restrain the bank from taking any steps in respect of the subject property. Stop. Learned advocate representing the bank relies upon a paper book which was filed before the Kolkata Debts Recovery Tribunal -III.
but only one paragraph from it.
Under section 19 of the Recovery of Debts Due to Banks and Financial Institution Act 1993, being OA number 84 of 2020. Stop. On a perusal of the cause title of the original application, it appears that the petitioner has been impleaded as the defendant number 3 in the said matter. Stop. The matter is still pending consideration before the tribunal. Stop. Learned advocate representing the bank asserts that summons were served upon all the parties and all the defendants in the original application have been restrained from taking any steps in respect of the subject property. Stop. Next. The petitioner asserts that copy of the summons were not served on him and the petitioner is not aware of the pendency of the said proceeding before the tribunal. Stop. Next. The bank is directed to file an affidavit disclosing its stand by 18th of July. Stop. Release the matter on 28th of July, 2025.
Well, let them say one more line whether they have title deed with them or not. If so, they disclose.
The bank shall disclose in the affidavit as to whether the original title deed of the subject property is in the custody of the bank or not.
Right. And in the meantime, they will not dispose of the property.
Nothing.
Yesterday, they have put padlock.
Very well.
Okay.
My lord, I appear for the petitioner, but kindly seize your lordship's last order. My lord, I am aggrieved by page 49, serial number 1.
Did you get this? 30th of June 2025. Give a copy. What is here?
Well, my lord, they took a hearing after another hearing when the lordship kindly see my lord meet poster. Another day conducted 30th June so during the hearing, both parties appeared except Bablu Das. The petition hearing, it was informed by Bappa Das, son of Bablu Das, that see Bablu Das is seriously ill and hence could not be present. It came light during the hearing as stated see Bappa Das alleged Sumit Das the following the order of the subdivision of so likely at the 18 had provided a room measuring about so Sobhita Das and Lawrence are duly food. However, due to some dispute that arose, they continue providing basic livelihood supporters. Sobhita Das, next one, Sobhita Das, daughter of Franco, confirmed that the Bablu Das had indeed provided a room about Franco, which is presently under her control and secured her lock and key. However, she stated that although daily livelihood support was provided only for 2 days, no food was supplied. Thereafter, it came to know that she is staying at she's elder daughter's house at Noyati. And title suit is pending. This is the present position.
So, the petitioner alleged that you could not have directed the petitioner to pay.
That is well, Lordship kindly see. As per inquiry conduct, I am coming. Based on Lordship kindly similar 1, 2,
Humanitarian reasons.
Based on the report and concerning humanitarian reasons. The public given case was addressed with, and it was directed from the only humanitarian.
So, by humanitarian grounds, you cannot infringe upon somebody's civil rights.
My lord, kindly.
It's my married sister. That she
has her
and
own
her
husband.
daughter.
She has 2 daughters. My lord, she has her matrimonial home. My lord, property belonged to the father. Father died. Mother and brothers and sisters, they became the owners. Mother died.
Oh,
brother-
sister is also the owner.
My sister is also the owner. I do not deny that.
Right.
But how can the SDO, my lord, step into this and say that I have to give, my lord, provide basic maintenance? So far as house is concerned, she is coming and deciding that I do not have any issues. Kindly seize the order. I have to provide basic livelihood from them from the income generated by Bappa Hotel.
Are you representing? Are you representing anybody?
Yes.
Who are you
My lord,
representing?
6.
Six respondents, I am sister.
Sobhita
But the SDO has
One minute, one
completely
minute.
acted in
Respondent
for
6
exercise
is
of his
represented. All right. Now,
Kindly come to page 33. Annexure P4.
yes.
On above consideration of humanitarian grounds and safety of a woman and a daughter, my lord, kindly mark the word safety. It is directed that Sri Bablu Das to allow safe stay of Srimati Shobhita Das, daughter of late Horen Das, in the property along with him, and will provide basic livelihood for her and daughter from the income of the property Bappa Hotel.
Where from?
Yes.
Yes.
Is
Now, my lord,
from the income.
my lord, kindly come to page 49. That's the order they have challenged.
Yes.
Page 49.
The SDO
1 minute,
has
1
said
minute.
to-
Yes.
My lord, kindly come to point 3. It's paragraph 3. In response, Sri Bablu Das and Sri Bappa Das asserted that the property Bappa Hotel is ancestral and Srimati Shobhita Das is not entitled to stay there.
Yes.
Then come to 5. During the hearing, Sri Bappa Das exhibited aggressive behavior towards the executive magistrate. That's why order has been passed, a case to be initiated.
Case initiate, let it be initiated. No difficulty
Yes.
with that. But then the SDO cannot step in and say that somebody is going to stay here and you have to provide food and you have to provide maintenance and everything. Can the SDO say so? Under which provision of law?
Maintenance of senior citizen.
She's not
Why
a
will-
senior citizen.
Why will the Senior Citizen Act come in over here?
Now, my lord, title suit has been filed.
The title suit will continue.
And no, that's all. Injunction order has been passed
Very
and
well.
that has been made absolute.
Very well, no difficulty.
I am contesting it.
As regards civil rights, the SDO possibly doesn't have anything to say.
Because of the Bappa Hotel is ancestral. And
You obtain an order from the civil
Well,
court
yes,
with regard to that.
When it comes to page 37,
The
please
SDO must
absolutely.
step in. Right.
but
This
she
is
is not allowed to stay in her ancestral home. That's why she has been forced to.
That is
No,
in the report.
she is not staying there.
That is in the report.
She is staying her daughter's house.
Yes.
She is not staying in ancestral home
She is in
because of them.
She is in possession of 10/12.
no. Thing is, if she is not allowed to stay, she is not allowed to enter. Obtain an order
Yes.
from the civil court and get it done. SDO cannot step in.
Senior citizen.
She may have been wronged.
Yes, that's
This
right.
the court can understand. But then her remedy lies elsewhere and not before the SDO. It is as simple as this. Please come.
Record the submission.
Please come. Give a copy to him also. The SDO today's report.
Yes,
Make a photocopy and give, otherwise he'll make a photocopy. Take a photocopy. Peruse the report of the subdivisional officer Kollani Nodia dated 30th June 2025. Stop. It appears that the said officer conducted a hearing on 30th June 25. Stop. The son of the petitioner appeared in the hearing and the private party was also present. Stop. It has come to light that a titled suit being TS case number 178 of 2022 in respect of the ancestral house of the parties is pending consideration before the learned civil court. Stop. It will be open for the parties to take appropriate steps before the learned civil court in respect of their civil rights. Stop. The SDO ought not to have directed the petitioner to provide basic livelihood to the private respondent from the income generated by the hotel run by the petitioner. Stop. If the private respondent has any claim with regard to the business, the remedy to obtain any share therefrom would lie before the competent civil forum. Stop. The subdivisional officer could not have entered into to decide any civil disputes in between the parties. Stop. The writ petition stands disposed of.
Lordship would say
A copy of the report placed in court today be handed over to the learned advocate representing the petitioner and the private respondent.
Could that portion of that order be set aside? One, providing basic livelihood, let the others remain. That portion be set aside.
I have mentioned that it could not have directed.
Should I appear for the petitioner?
Yes.
I appear for the oil companies. Lordship will take partly redressed. Not it's an area dues of rent, not for occupation which they want to renew the lease from 1996 onwards. But for the period from 1996 to 2019, they are not agreeable to pay as of date. From 2019, they have quoted a rate. We have not objected to the same. For the time being, let them release the amount from 2019 to June 2025. The admitted amount.
That manner.
Without prejudice to our right.
Not in that manner. It should be decided in as a whole. This writ petition is expressly not maintainable. They are seeking eviction and mean profit. My lord, since it was Lordship's desire, my lord, we called them for a reconciliation meeting, my lord, in which, my lord, in the writ petition, they have claimed.
If you say the court will not enter into all these things, if you say I'll adjourn it to proceed with your settlement.
Lordship will kindly send this for mediation, my lord, to the mediation center.
No, they have agreed to this.
No, they have not agreed. My lord, they have asked
for. Do you think mediation will help?
My lord,
if you can mediate, it will be mediated, not by any third party mediator.
It will be very difficult because area rent they claimed in the writ petition 15 lakh. Now they are claiming 2 crores.
No, it's not that. No, I have
yes.
On the basis of their own calculation, we have
my calculation is
I'll send it to the Lok Adalat or what?
There is no point in going before the Lok Adalat.
My lord,
It
this
goes
is,
on for
my lord, we have sat with them on 3 occasions. Main difficulty is there. There are 3
3
sets of
occasions, 30 occasions, I do not know. Say yes or no, I'll decide, I'll finish it off or I'll adjourn.
when all the co-sharers are not ad item, my lord.
no,
The,
it's
the
not that.
fresh, my lord, the fresh lease has to be executed by all the co-sharers.
That's right.
My lord, as on record, we do not know whether all the co-sharers are also selling in the same boat or not. Because they are not in the meeting, they are not speaking in the same voice.
Listen, if all these disputes comes up, then your writ petition will go. So it is better you sit with them and finish it off, or otherwise go before a suit court or do whatever you feel like.
We are ready to sit again, my lord. There is no difficulty on our part, my lord.
What I am saying.
We want to resolve, but if they claim
why
such absurd amount,
I started off by saying that it has been partly resolved.
it has not been, my lord.
Anyway, if the petitioner feels it's partly resolved, let him be happy with it.
They have given a rate of rent from 20
Whatever, I'll adjourn it. Please
2024.
come.
Let them
Please
calculate
come.
on these basis from the period from 1996.
No.
It
Why?
appears from the submission
Under
made on
2020
behalf of the
blank
parties that
What has been?
talks of settlement are still on. Stop. The not the hearing of the matter stands adjourned till 5th August. Enough time.
My lord. তাই দিচ্ছে না তো admissible dues টাও দিচ্ছে না।
It will be open for the parties to get the matter settled between themselves out of court.
Lordship.
Add up Koronin. Please add up. It will be open for the parties to settle the disputes in between themselves amicably out of court.
Lordship.
Yes, next.
My lord, I am for the petitioner. My lord, that matter,
My
where,
lord,
my lord, the
before-
public prosecutor is the father and
My lord,
counsel for
would
the de facto
be
is the
kind enough to, my lord, dismiss this petition because of serious suppression of fact. The similar application was moved before the additional session judge, and there is a judicial order by the court rejecting his prayer, giving reasons. And this has neither been disclosed,
the facts do not
and
change.
therefore, no. Therefore, my lord, this petition cannot be, in my humble submission, kept on record.
Are you aware of this?
But that facts do not change, my lord. That the
And
father
it's
and
on
No, it
4th of April. The order is dated 4th April 2025. It's
Yes.
an absolute
That was on
fresh
his
order.
on his application. This order was passed by the session trial. Yes, this is the application. Lord, the
17th of May, immediately after it is dismissed before the learned trial court,
Yes.
it comes up over here. Then you should go in a civil revision application.
Yes.
How is the writ petition maintainable with the same prayer?
that upon such above-mentioned allegation, accused persons have prayed for necessary order on the ground that fair trial is not possible. And the court has gone in detail to that and said that this is a frivolous application.
my lord, I do not know.
তোমাকে দেয়নি
Please check up, please come.
ও দিয়েছে তোমাকে দিয়েছে
Learned senior counsel representing the private respondent
Yes.
produces copy of the order number 59 dated 4th April 2025 passed by the learned additional sessions judge, comma 10th court, comma Alipur in ST 01 within bracket 11 2022 R number 61 of 2020 rejecting the prayer of the petitioner for change of the public prosecutor. Stop. Next. It has been submitted that if the petitioner is aggrieved by the order passed by the learned trial court, comma, the petitioner ought to have approached the revisional court under Article 227. Stop. The petitioner could not have approached the constitutional court under Article 226 of the Constitution. Yes, please.
Well, kindly give me a day's time. Let me
Yes.
ascertain. Or kindly keeps it next week, my lord. Let me ascertain.
Learned senior counsel representing the petitioner seeks time to take instruction. Released 10th July, next Thursday.
No.
This is a certified copy. Will I keep it? I can keep
I
copies
shall be able-
also.
I shall take
Yes.
copy. দেখি দাও।
Right, take the certified copy. ওইটা
একটা
দিন।
copy, এই নাও।
A copy of the order dated
ঠিক আছে।
4th April 2025 be written with the records. রেখে দিন।
কোন নোট? এখন এখানে মেনশন হয় নাকি? স্যারের ফেল। এটা আমার
Item number 92.
My lord, I am for the petitioner.
Yes.
My lord, the respondent number 3 suppressed read application before Honorable Justice Subhajyoti Bhattacharya submitted read application over to Honorable Justice Subhajyoti Bhattacharya suppressing fact the right title, interest and suit for possession of the disputed property are pending before learned civil judge 4th court junior division Alipur without keeping the petitioner as a party, without serving a copy of this petition to him. Upon hearing, Honorable Court directed the government authorities for personal hearing on cogent decision on cogent evidence on the right title interest of the property.
What is under challenge over here?
Madam, this is not under challenge. 2 suits are pending. Under these circumstances, you came to Honorable High Court suppressing these facts to grab this property. Now, thing is, let the personal hearing was taken twice on 2nd April, 30th April, respectively, but no decision was communicated. Under the circumstances, the read application was filed. Now, let the judgments and decrees are passed on this disputed property until and unless it is passed. So, the respondents cannot take any step on right title interest of this property. This is my submission.
I have not followed a bit of it. I can see one order annexed at page 9, 22nd, 26th of February 24, filed by one Taposh Kumar Ghosh. He is the private respondent over here. Right.
Number 3.
Now what has happened? Did you serve?
Has copy is served.
All right. Now?
The thing is, Ajit Kumar Ghosh, the deceased father of Taposh Kumar Ghosh, came from Pakistan immediately after independence. He got land from the Rehabilitation Department.
Listen, page 10, I can see the court directed the respondent to consider the representation of the petitioner upon giving opportunity to the petitioner to produce all documents. Now, what is the problem?
The result of personal hearing was not communicated.
Do you want that only?
I want that one. That my lord, recently they communicated to me.
Yes.
To communicate them, solemn order of Honorable Court of Learned Court respectively on the truth cases and writ matter. This is their last intimation to us.
Where is the last intimation? Let me see.
That is not with me at the moment.
Then
So far that petition is concerned, Lordship will find, my lord, some Taposh Kumar Ghosh has
private
filed
respondent.
petition, private respondent, and my lord, in that letter, my lord, which has been mentioned, my lord, that has been written to, my lord, the Deputy Controller of Rehabilitation. In the 2nd page, that Taposh Kumar Ghosh did not mention before the Honorable Court dated so that a title suit is pending before the learned civil judge 4th Court Junior Division Alipur on the right title of interest. Now, my lord, what his basic intention is, my lord, there is a dispute with Taposh Kumar Ghosh and this petitioner. So you cannot take my property since the civil suit is pending.
Yes, so you go and raise issues over there. What can this court do now at this stage?
My lord, he submitted his application before Honorable Court, suppressing fact that.
So if you are aggrieved by that, you pray for recalling of that order or whatever you've got to do. What the court will do?
Honorable Court directed the government authorities for personal hearing to take cogent evidence on right, to take cogent decision on right title interest of the property on cogent document. Personal hearing was taken, but result was not communicated.
You say a communication was made. Where is that communication? Show it to me.
Very recent communication. This is not.
Show it.
So we are needing communication. Let them.
Because, my lord, because he is not the party to that proceedings.
I'm a petitioner hearing.
Is that matter where you were party?
I was not a party, but I was.
Yes, so why will that, this is the stand of the respondent, since you were not a party, accordingly the order has not been communicated to you.
Participate in the personal hearing. I was.
Was a hearing given to you?
Personal hearing was.
Show me the notice of hearing. Where is the notice of hearing? Please come.
Even nothing has been disclosed in his letter also that he has participated in the hearing.
The petitioner claims a certain right, title, and interest in respect of a property.
No, kindly see. Kindly see page 13. Kindly see page 13. I pointed with reference to read petition number such and the discussions were made before you on as respectively on claim of the disputed property on such on cogent papers of Ramdas Ghosh and Tapas Kumar Ghosh for ownership of the said property, but no decision was communicated to say
In respect of a cumulum,
still dead.
in respect of a property,
This is for
respect of a property.
Undated letter.
কোথায় undated?
Absolutely undated.
Undated.
এখানে কিছু লাগে এর ছাপ কোথায়?
কোথায় ছাপ? কিসের ছাপ?
In respect of which an order was passed by the court by a coordinate bench of this court on 26th February 2024 in WPA 21886 of 2023 within bracket Taposh Kumar Ghosh versus State of West Bengal and others. Stop. Taposh is your brother or what?
My cousin.
Cousin brother?
Yes.
Mother, have your lordship seen page 13?
Yes, I have seen. Answer. Learned advocate for the petitioner submits that a hearing was conducted by the authority in compliance of the direction passed by the court in the aforesaid writ petition. Stop. The petitioner was also directed to appear in the hearing. The petitioner was directed to appear in the hearing. Stop. The fate of the hearing has not been made known to the petitioner till date. Stop. It has been submitted that civil suit in respect of the subject property, two suits. Suits in respect of the subject property is pending consideration. Stop. Paragraph. None represents the private respondent. Where is your affidavit of service? Affidavit of service filed in court is taken on record. Paragraph. The instant writ petition is disposed of by directing the Deputy Controller, Deputy Refugee Rehabilitation Commissioner. Who took the hearing? To communicate the fate of the hearing conducted.
Deputy Refugee Rehabilitation Commissioner.
Conducted in compliance of the direction passed by the court on 26th February 2024. If not communicated in the meantime, writ petition disposed.
ওটা আপনাকে পাঠিয়ে দিতে বলেছি গেটফুল মানে
But date of hearing 2 days 2nd April 3rd April 2024.
Acha, hearing conducted on 2nd and 3rd April 2024.
2nd and 30th April.
Or 2nd and 30th April 2024.
Page 13. It is
গেটফুল
693.
My lord, I am for the petitioner, my lord. But the affidavit of service be kept in the record.
Yes.
My lord, the petitioner took part in a e-tender process, my lord. Thereafter, being selected, my lord, have conducted the work as per the terms and conditions, my lord. Thereafter, my lord, after completions, my lord, the petitioner has issued several representation before the
Seeking payment?
No, my lord.
Then?
To provide me the completion certificate, my lord. The
Completion certificate?
Yes, my lord.
It has not been served?
No. My lord,
Where did you perform the work?
my lord, at Murshidabad, my lord.
Archaeological Survey of India?
Yes, my lord.
Show me that the work order was given to you.
My lord.
And when was the work completed?
My lord, the work order is at page 45, my lord.
Yes. Page 45, I cannot see the date. 2022.
Yes, my lord.
Then what happened?
Then after, my lord,
Will be
after being
5.5 months, yes, March 23. Then what happened?
there, my lord, after being completed, my lord, I have made several representation before the concerned authorities to provide me the completion certificate, my lord. Thereafter, they haven't issued, my lord. My lord, I cannot take part in any tender process, my lord, because there is a shortfall in the eligibility criteria, my lord. This is the difficulty, my lord. I have prayed before the concerned authority to provide me at least the completion
Place your
certificate.
representation.
My lord, the representation starts from page 53, my lord.
53. You do not want payment of the bills for the
My
work?
lord, the payment has been done, my lord.
All complete payment
My
done?
lord, my lord. Payment has been. Security deposit has been returned, my returned to me.
Only the completion
Yes,
certificate
my lord.
has been done? Please come. The petitioner is aggrieved by the act on the part of the Archaeological Survey of India
Yes.
in not issuing a completion certificate despite successful completion of the work in terms of the work order and upon payment of the bills and releasing the security deposit. Stop. Paragraph. The petitioner applied before the authority for issuance of a completion certificate, but the same has not been issued till date. Stop. None represents the respondent authority despite service. Affidavit of service filed in court is taken on record. In the absence of the authority, comma, the court is not in a position to ascertain as to why the completion certificate was not issued in favor of the petitioner. Stop. The petitioner asserts that all payment and security deposit and performance security has been released. Stop. In such a position, the completion certificate ought not to have been withheld. Stop. Be that as it may, as a prayer from the petitioner for issuing the completion certificate is pending consideration before the authority, accordingly, the instant writ petition is disposed of by directing the respondent number 2 to consider the prayer of the petitioner for issuance of the completion certificate in terms of the contract issued at the earliest, but positively within a period of 3 weeks from the date of communication of this order. Stop. Learned advocate for the petitioner is directed to forward copy of all documents in support of his claim. It's a form. To the aforesaid respondent at the time of communicating the order of the court. Disposed. Next.
694. 694.
Private respondent number 3, my lord.
Please record your appearance. It's being dismissed for default.
695.
694. I am appearing on behalf of the petitioner.
For the state respondent.
Considered a victim, my lord.
And my
Her
lord,
left side has completely damaged. Even her left thigh completely damaged. Percentage of disability 50%. I have annexed that. My lord, initially she received rupees 3 lakhs also, but subsequently, my lord, her other requirements are also there. My lord, I have come before your lordships, my lord. Number one, my lord, there is a scheme, my lord, NALSA scheme. Your lordships knows everything. There is, my lord, the range of 3 lakhs to 8 lakhs, my lord. I need some more money for my treatment, my lord. A particular scheme is to be formulated. Till date, no scheme has been formulated.
You received 3.
Only 3 lakhs, my lord. And my lord, in my prayer, I have.
Where is your prayer before the authority?
Yes, my lord.
Where is your prayer?
Prayer, authority, prayer.
Lordship, I am appealing on behalf of the SLSA.
Yes.
As per existing scheme, West Bengal Victim Compensation Scheme 2017, Lordship,
there is a procedure for grant of compensation, Lordship. For that, the victim has to be made an application before the authority, DLSA, concerned DLSA, and after that, if he or she is aggrieved by the compensation, Lordship, there is also a appeal provision, Lordship. Here, Lordship, the victim received rupees 3 lakh as a compensation through a government fund, although it is released by the SLSA, Lordship, but it is not, they have never preferred any application, Lordship.
No enhancement, no prayer for enhancement has been made by the petitioner.
So there is a procedure, Lordship. If
Yes,
they
I
apply
understand,
for
but then
that-
you have to apply.
My
Did
lord,
you
I can
apply?
apply. At the same time, my lord, I have some more prayers, my lord. I have annexed another judgment of the Honorable Coordinate Bench. There, my lord, one of our petitioners, separate, my lord, she claimed a pension also, and my lord, Honorable Coordinate Bench passed a direction in that regard also. Rupees 10,000 was allowed for her as pension. My lord, till date, she did not receive any pension. But my lord, this will be my number one prayer, because my lord, you'll
No, but then you have to make all these prayer before the authority, because the authority does not know that you require this. What was there, the minimum 3 lakh has been given to you.
my lord.
Rest, you need more.
Yes, my
So
lord.
you have to
And my
make
lord,
a prayer.
my day-to-day expenditure, that also.
Everything also
Yes, my
you have to,
my lord,
till
then my lord,
you
liberty
raise a
given,
grievance,
my lord.
how will the authority get to know that
My lord,
this is
liberty
your
be
prayer?
given, I shall pray
Lord,
before the SLSA.
I'm appearing.
SLSA, my lord, is only the disbursing authority. My lord, SLSA.
You have not made prayer before any authority, not also before the state.
And Lordship, if your Lordship kindly come to page 127, Lordship, that is annexure P4, that is a sanction order, there's rupees 3 lakhs is disbursed, Lordship. But Lordship kindly consider that pursuant to the notification dated so and so, dated 27th of April 2015 of the Government of West Bengal Home Department, it is Lordship allowed.
Lord, Home
not
Department,
by
we have made them party, my lord. In each and every case,
Presentation
prayer
is
is
not
not
being
required. But we
No.
come before this honorable court. Honorable court passes order. Thereafter, we go to them. They disburse the amount, my lord. In each and every case, I can show. I have annexed these orders also, my lord. Kindly comes to page 145. In these cases also, we did not go directly to them, because we know they are only the disbursing authority. Until and unless home department, they are allotting money to disburse to acid attack victims, they did not give, my lord. They do not give generally. My lord, kindly comes to page 145. Page 145, relevant part is in page 146. 146, first 4 lines, thereafter page paragraph 8, thereafter paragraph 10. My lord, I kindly allow me to read, my lord. Paragraph 8, accordingly, WPA such and such is allowed, thereby directing the respondent number 3 to ensure that the total compensation amount of rupees 8 lakh is immediately be released to the respondent number 6 for the purpose of disbursal to the petitioner. Such release shall take place as expeditiously as possible, positively within January 15, 2024. The respondent number 6 within 4 weeks thereafter shall disburse the amount to the petitioner. SLSA is only disbursing authority. In terms of the provisions of the compensation scheme for women victim / survivors of sexual assault and other crimes 2018 as annexed to the present writ petition. Paragraph 10. As rightly pointed out by the learned counsel for the petitioner, the respondent number 1 state in tandem with respondent number 6 should also formulate a comprehensive scheme for grant of regular pension of victims of acid attack similarly placed as the petitioner. My lord, till date, as we know, my lord, no scheme has been formulated, my lord.
Tell me one thing.
My lord.
Will it be a proper thing that each and every case a victim has to approach the court for relief?
No.
This will not be proper.
I bowed. I could not.
In each and every case, a victim ought not to be compelled to come to court.
Yes, in each and every case, my lord, we are coming before your lordship. Thereafter, we get order, my lord.
Yes.
In each and every case.
So
otherwise, they do not give.
The submission, otherwise they do not give.
My lord.
You have to make a prayer that yes, this has been given. I want more. This is my condition. Right?
My lord,
this is what I was.
Our prayer.
Anyway, what is your submission?
My lord, the paragraph 10 was shown. Paragraph 11, kindly see, it says it is expected that a formulation of such a scheme shall be explored and if otherwise feasible, effected at the earliest positively by January 31st, 2024, as and when formulated, the petitioner's case shall also be considered under such scheme, subject to the petitioner applying thereunder.
This is
As your, may I just kindly, this is one. So, my lord, there has to be a policy decision, absolutely. My lord,
No, this is regarding the pension.
Pension, right? No, it is regarding everything. It's regarding everything. Because this case deals with the percentage of disability and the compensation.
Here, 10 and 11, if you read
the whole case
together.
Yes. My lord, it deals with everything. My lord, kindly come to page 153 for once. Another judgment by the coordinate bench, paragraph 23, kindly see. It's not automatic. It has to follow procedure. My lord, I understand the sensitivity of the issue, but it has to be.
Yes, page
Kindly see page 20, page 153, paragraph 23. It may not, however, be practicable for each state to implement the NALSA scheme rates of compensation to the letter, keeping in view the peculiar circumstances and characteristics of each state and its administration. Insofar as the rates contemplated under the NALSA scheme is concerned, the court cannot direct an in toto implementation of the exact rates stipulated by NALSA scheme in the state. It also has to be taken note of that the West Bengal Victim Compensation Scheme has been formulated not under the direction in Nipun Saxena, but in exercise of the powers conferred of Section 357A of the CRPC, and thus the direction in Nipun Saxena does not strictly apply thereto. Now, my humble submission in this regard is that, my lord, absolutely there is an NALSA scheme. What my learned senior friend is seeking for, parity with that central scheme or enhanced rate, because it is of 2017.
I am not going into anything.
Yes,
I'll keep
that's
the
what I'm-
petition pending, let her apply. I'll see what is done.
Or my lord, can it dispose it of?
No, I'll not dispose it off. You do not want another victim or this victim to approach the court all over again.
Absolutely not, my lord.
She has already come.
I'm not acting
Let
as adversary.
Let her apply.
Yes,
It will be seen.
I'm not acting as adversary.
Please
in
take
accordance
down.
with the scheme, my lord. That is my humble.
The petitioner.
As per scheme lordship, section 6, there is specifically mentioned the procedure for grant of
That is
compensation.
2017. That is 2017.
My learned brother was saying about
After 17, it has not been updated, isn't it?
It's a policy decision, my lord.
Right.
That's possible.
So it has to come from here, and Justice Bhattacharya's order
Yes.
with regard to policy is already there.
Yes, my lord. Justice Bhattacharya's order is very specific that I may not accept the NALSA.
Is a victim
amount.
of
It is not mandatory on
acid attack. Stop. She has been provided the victim compensation of a sum of rupees 3 lakh
Yes, my lord.
in terms of the this what is the name scheme? West Bengal Victim Compensation Scheme, 2012.
2017. 2017.
Page 127, I have annexed.
2017, sir. 2017.
2012. West Bengal Victim Compensation 2012.
17.
Is the 12 and 17 scheme same? The figures?
It should be
No.
17, possibly.
Page 127, it mentions compensation scheme 12. আচ্ছা, ঠিক আছে, 12 থেকে 12
My
থাক।
instruction is this, lordship. This compensation was not dispersed as per victim compensation 2017, lordship. As lordship, they have never applied for the.
All right. আচ্ছা, the petitioner
This is as
submits
per
that
the Department of Home.
she is in need of more compensation as the condition, as her health condition has deteriorated further. Stop. Paragraph. Learned advocate representing State Legal Services Authority submits upon instruction that there is a provision for the victim applying for compensation under the 2017 scheme. Stop. The petitioner has not made any application till date. Stop. Paragraph. Hearing of the instant writ petition stands adjourned till 5th August 2025. Stop. The petitioner is granted liberty to forthwith apply under the scheme of 2017. Stop. The authority is directed to disburse the amount in favor of the, not amount, compensation in favor of the petitioner within a fortnight from the date of application.
Grateful.
Lord, as permissible under the scheme, because there has to be parameters. How much,
The
the
court has
percentage.
not mentioned any figure.
No, your lordship said it
Why?
has to be disbursed.
Yes.
Lord, it has to be checked first, whether she's
Check.
eligible.
Who's stopping you? Nobody is
If
stopping
she's
you.
not eligible, suppose, my lord, 50%, 55%, 100%.
You say she is not eligible. The matter is kept pending. It is only for this reason.
Since your lordship given a specific direction upon the authority to disburse, it may not act down. It's
That's the lead matter regarding modern.
This is-
Without any ask, we have mentioned that matter was fixed as a leave matter.
আমরা submission করছি মাঝে আনতে গেছে বসে শুরু করে।
If that's taken at 3 p.m., then we can sub notice from the government.
But then Justice Ghosh will be available tomorrow. You can make this prayer tomorrow also.
Sunday is the date of Mahadam.
So tomorrow is a working day. It's a Friday.
কবে আসবেন?
It's more difficult for parties to come,
কবে আসবে?
and gather the, after getting the permission, they can do the other works that are also required to be done for gate.
It can be done. It can be done. It won't be difficult.
My lord, may I, the compelling circumstances, my lord, may I mention one matter with regard to item number 377 of your lordship's today's list, my lord. My lord, this matter is related to water connection, my lord. In spite of specific direction passed by your lordships, my lord, the contempt,
Why are you mentioning now?
my lord. My lord, as because my lord, this is contempt matter will be taken up at who, my lord?
Yes. Is your other side there? Are you aware who your other
If-
side is?
My lord, if your lordship kindly take up this matter next week, my lord. In the meantime, my lord, I will serve the notice, my lord.
Is it appearing for the first time?
No, my lord.
Notice has been served.
Yes, my lord.
Please wait. Yes, item 1.
My lord, item 1, I appear for the alleged contempt, your lordship. Your lordship on
I
the
am for the contempt number 2, my lord.
lordship
Led by
directed
Mr. Mole.
file my affidavit of asset, my lord. My lord, I am filing the affidavit of asset, my lord. And my lord,
What happened to the appeal?
my lord, appeal dismissed, your lordship. I have the order of the appeal.
Yes.
Yes, my lord, the appellate court stated that it is your lordship who will decide, as I am in contempt of your lordship's order, as on the date of the order, I was the chairman of the municipality. My lord, I tried my luck, your lordship. Anyhow, my lord, the affidavit of asset, my lord, I have made it ready for your lordship's consideration. The entire amount, my lord, has been paid by the municipality. So nothing
By
is
the
due as of.
municipality, but then you did not, when you were in
My lord, I could not.
the
My lord, I was
post.
thrown out from the post of chairmanship. That was my plea. I have filed an affidavit of compliance even before your lordship to say that I was thrown out of the party. I was thrown out of the post. And it was without, outside my purview and control and power, my lord, to abide and, my lord, to comply with your lordship's order. I tried my best, my lord, and part payments were made during the time I was the chairperson. But after that, my lord, when I was removed, my lord, the newspaper publication, everything I have attached with my compliance report, my lord, it was outside the, my lord, scope that I could, my lord, comply with the order of your lordship. I tried my best, my lord, part payments have been made till the time I was the chairperson.
Affidavit of assets?
Yes.
You have not mentioned anything.
Yes, my lord, I have whatever asset I have got, I have mentioned.
You mentioned.
Yes, my lord, kindly
Mention the term deposit numbers. Where are the figures? Where is your asset? Number is not the
my lord, just a
asset.
moment. My lord, just a moment. হলো না এটা ওটা দেখাও এফিডেভিট অফ অ্যাসেট খুলে একাকার কাণ্ড হয়েছে
I possess the following. Page 8.
Yes, your lord.
H.
Yes, my lord. One second, your lordship. May I come? My lord.
I possess the following. Bank account. Where is the amount? Bank account. No amount. KVP. No amount. Term deposit from 6 to 15. Nothing mentioned. Is this mockery with the court or what?
No, my lord, I have mentioned.
What is it?
My lord, then I will again file, my lord, disclosing the amount.
Your client is trying to act smart.
No, my lord, my client
or
has...
the client is being misguided by the learned advocate. I do not know, because this has been prepared by a learned advocate,
yes,
not by the client. Is this the way how an affidavit of assets is to be given?
Well, then I'll attach the accounts, attach the annexures.
Why did you put it by? You could have given the number. You have given the number.
Yes.
Why is the figure not mentioned? Yes. Any explanation?
No, my lord. No. I will. Your lordship directs. I will, my lord, attach the entire certificate.
Just imagine a list of term deposits, not a single figure disclosed. This is the affidavit of assets.
My lord, my lord, tender my apology, my lord. Your lordship directs.
Social worker? Is this how you are?
No, your lordship directs, my lord. I will attach, my lord, the certificates. The certificate itself I will attach.
Nothing.
My lord, I have nothing to, my lord, shy away. I have nothing to shy away. My lord,
what you are saying and what is appearing from records is completely
lord,
different.
There has been, my lord, it's a fault on my part, my lord. I'll say.
I'll say the affidavit of assets of the contender number 1. Contender number 1.
Yes, contender number 1.
Yes.
Filed in court today is perused. Stop. It appears that the details of the asset have not been disclosed. Stop. The said affidavit cannot be treated as an affidavit of assets. Stop. Paragraph. The same is accordingly not accepted by the court. Stop. Let proper affidavit of assets disclosing all figures
Yes.
be prepared
My lord, your lordship
and
kindly
filed
directs for attachment of the
on the next
certificate.
date, 7th August.
No, 7th August. Very well. Deeply obliged, Your Lordship.
Next.
Here I am for the state, along with Mr. Learned AGP, my lord.
Who I am for the petitioner.
আমি আর প্রীতম আছি actually
It was heard on the last occasion. Your lordship, my lord, the
Mr. Shantanu, on the
Yes, ma'am.
last occasion, the way you appeared virtually is absolutely
My lord.
improper.
My lord, I sought apology that time, my lord, because no
You
notice
should
was
not
served
have,
to us,
you
my
at
lord.
least should have not opened the video. Audio could have been heard, but on the video, you are before a court. You cannot appear in that manner. You have to understand that.
My lord,
Anyway, what the matter is?
my lord, the page 16, 16.
Yes.
And my lord gave direction to the petitioner to serve notice. This time also they have not served notice to
I
us
tell you, lordship,
about
page
today's date.
16. हाँ, बोलते रहो।
The
मैं कोई भी
petition was,
lordship
my lord, disposed of, my lord, directing the giving liberty to the petitioner to apply afresh. This is an application for transfer. Since the petitioner is single teacher, and my lord, your lordship,
His submission is that the court directed to consider the case in terms of the notification of 2022 and the application for transfer was made prior thereto. So it has to be considered on the basis of the notification which was prevailing on the date of the
Yes, that is my
application.
view.
This is his prayer.
That is my
it
prayer.
has already been decided by the division bench of this honorable high court, my lord. I have not appeared, I am not appeared in this matter, my lord, in the writ petition as well as the when the appeal was moved before the honorable division bench in this matter.
In this matter, you didn't
Yes,
appear.
my lord, appeal was moved and liberty was granted, my lord, kindly turns to page 22 of this application.
Yes, I have seen that.
That was placed.
This has been placed. Do you want to rely upon any judgment or something?
Another judgment, my lord, presently, my lord, the
He
coordinate
wants,
bench,
I tell you, lordship, he wants to
Presently-
place the judgment even single teacher on the ground of single teacher. My lord, the transfer cannot be rejected because division means give 6 months times. By these times, alternative arrangement, otherwise transfer will be. That is not the case mine. My case is my application prior to amendment where the single teacher conception comes.
my lord,
Yes.
delay-
This is the, my lord, the only you lordship direct
point
the
of delay, my lord.
and
My lord, since, my lord, he made an application before the school authority for transfer, my lord, in the year 2021.
Yes.
that's
My lord,
good.
the portal was in operation, my lord, up to, my lord, 30th September 2022. Why he has not made any application before the honorable court? After 4 years, why he has come before
All
the court?
points have been considered by
He
the
has
honorable
to, my
division
lord,
bench.
explain.
Division bench, I have annexed in my writ petition. Division bench clearly says, my lord, kindly see my writ petition.
The liberty
Two-
was given
two
to.
Very well,
division
you
is al-
place the judgment what you want to place.
Yes, my lord,
Please come.
I am, my lord, suggesting, my lord, and in order to assist my learned friend's client, my lord, the division bench observe that, my lord, there is a provision of.
Bring the judgment and let
No, my
we
lord, I
can-
have annexed the division bench
না,
judgment.
না, এটা বলছে না।
ওই জাজমেন্টই দিয়েছি পেজ 69 you will also kindly see in my writ petition
Yes.
there are 2 division bench I have annexed in that judgment also my lord the application was made in 2021 so division bench said that transfer application you will also page 69
Yes.
we had also clarified that transfer application should be considered on the basis of the norms prevailing at the relevant point of time, not on the basis of the subsequent. This is the this is the thereafter direct the school service commission to consider in terms of the 2015 rules. Now another division bench page 72. All division bench judgment in all times directed that application should be made on the basis of the application.
True, but then in this case, application was in 21 and we are in 2025. Do you still think that it has to be considered on the basis of the prevailing rules. You did not approach the court in proper time. You made an application long after the 2022 notification came into force.
That's true. Division bench said that all those
Division bench said it in December 23.
23,
Immediately
but
after,
application was made, all application was made prior to suspension.
yes,
21
now,
or 22.
right. Now,
Everybody,
it was there till 22. Till 22 it was there. You came at quite a delayed point of time.
this, well, the page 16 School Service Commission returned my application on the wrong conception. This is
Now what is to be done? Assuming it is in the under the new
direct the School
scheme.
Service Commission to consider in accordance with law. I am not.
Since, my lord, we have rejected, the School Service Commission has rejected his prayer, my lord, and returned his application to the school authority. So, my lord, there is now presently no pending application. So, my lord, your lordships rightly, my lord, granted leave to the petitioner to apply afresh as per 3rd January notification.
No, that is the order I am on to
consider.
modification.
My lord, kindly, your lordships can modify that by stipulating a time upon the district inspector of school in order to find out the alternative arrangement.
What are you
Yes, my lord,
teaching? What are you teaching? Which subject?
The subject computer science.
Computer science is an important subject. So if you are transferred to some other school and there is no alternative arrangement over here, then the students will suffer.
After all, my lord, this is
Alternative arrangement, division clarified that up to February 2026, alternative arrangement, make alternative arrangement, otherwise he applicant will be transferred. This is the division man binding the time.
Where is it, that judgment?
kindly adjourn the matter, my lord. I shall bring.
That has been. That has been.
Time has been fixed by the division
Four
bench.
months has been given to the district.
Very well, then bring that judgment. Please come. To allow HUD submission made on behalf of all the parties. To allow the parties to produce the decision of the Honorable Division Bench, fixing the time within which the application for transfer, now within which alternative arrangement has to be made in case where there is an application for transfer of a single subject teacher. Come on, release the matter once again. When? Next Thursday? Next Thursday, 10th.
I have a copy even tomorrow I can. No.
Tomorrow it's not possible. Next Thursday, come. And give a copy to the learned friend also, so that. Very well. Then both can bring the copy.
My lord, can it be on Friday? Can it be on
Which
Friday?
Friday?
Next Friday, my lord.
No.
Instead of Thursday, my lord, Friday.
Why?
Because the circuit is running, my lord, and we have to appear virtually.
Why Friday circuit? Has it been restored?
No, my lord. Yes, my lord. It has been restored, and
Then Friday will be the same thing.
I have a copy. Just now, even after 5 minutes, I can produce.
Tomorrow it is not possible. In that case, Wednesday I keep it. Tuesday?
Tuesday.
Acha, ठीक है, 8th. Tuesday 8th.
My lord.
Tuesday.
My lord. And once again, my lord, I seek an apology for that.
Be careful. You may be steps could have been taken against you, the manner in which you appeared. Anyway, call the next one. Be careful.
Yes.
I appear for the applicant in this matter. I have served upon the corporation, my lord. My application for contempt, a lordship's order dated, my lord,
My instruction, my lord, neither the office concerned nor my lord, law office received my lord, this contempt application. At least 1 hour before that, the instruction I have once again collected.
They have not received.
That's my instruction, lordship. I do not know in which office, in which manner they have served it. The huge, my lord, at least no idea of the executive engineer as well as my lord, my law office.
Ataur Rahman, Executive Engineer, Boro 15, KMC,
Yes, yes, yes.
has been
I have
served
talked to him.
11th of April 2025. The affidavit of service says so.
Received, Lordship. It is showing received. I'm checking up. Maybe misplaced. Whatever it is, my Lord's order was originally to consider, because it's an unauthorized allegation of unauthorized construction. It's a, my Lord, 3-story building. One co-sharer, my Lord, made this allegation. One co-sharer. So my Lord directed you make.
Consider the representation.
Yes, consider it. That is, my Lord, under process.
2023. 2 years passed.
My Lord, kindly appreciate. They are not, because this is in between. Co-sharer alleging because of personal interest, whatever it is. Now, my Lord, all the documents which are asked for, not even produced by neither co-sharer nor other occupants. To determine, my Lord, direction was also there, make inspection, and you see the encroachment, how it is done. We have, my Lord, measurements have been made. What are the unauthorized portion?
Yes.
Yes.
And what are you waiting for?
Lordship, have a look to this. These are the
What are you waiting for?
only waiting for the, my Lord, their documents.
Which document?
Mutation paper. Whether
What has mutation got to do with unauthorized construction?
This part, my Lord, if at all, who would be responsible? First chance, my Lord, to be given of your own, you demolish it. Then, my Lord, otherwise it will be demolished by the corporation. Only to.
And for mutation, you must be having your own record. Suppose somebody does not produce a record deliberately. Will it mean that the unauthorized construction will remain?
No. My Lord's order is that has to be complied with. There is no, my Lord, no second thought.
2 years have passed.
This order, my Lord, February 25. Kindly see the ordering part.
Very well.
Second page.
I'll take steps against your executive engineer.
One more chance, Lordship, because copy I have not received. That's the information, Lordship.
This one more chance is being stretched to such an extent that orders of the courts are flouted day in and out.
It's not served. That's my Lord, specific instruction.
Please come.
Only one more chance, my Lord, I am coming.
The order of the court has not been complied till date.
Service part is there, Lordship. Kindly consider this.
The learned advocate representing the contemner seeks extension of time for complying the order of the court. It appears that order was passed on 4th July 2023.
One more chance, Lordship. I will.
For consideration of the petitioner's objection to an unauthorized construction within a period of 3 months from the date of communication of the order.
Order is very strict.
The authority is yet to comply the same.
One more chance, Lordship. The first day I am appearing.
Hearing of the contempt application. Hearing on the prayer of the learned advocate representing the contemner, hearing of the contempt application stands adjourned till 7th August 2025. An affidavit of compliance shall be filed on the adjourned date. The as regards the delay in complying the court's order, the same shall be taken up for consideration on the adjourned date.
Grateful Lordship, may I have a, my Lord, the service, affidavit of service, may I have a just look to it?
Yes, please.
Grateful Lordship.
The affidavit of service.
But I've served
taken on record.
No, that I have received. Without wrong. What is it?
Is it the same thing?
Yes, Lord. My application, my Lord, your Lordship's order dated 5th of July.
Same Monirul Islam Mollik?
Yes. Now, here, my Lord, an order was passed
But I've annexed the copy of the order. If I may place your lordship's order first, thereafter, my lord, I'll move on to the order passed by the special officer bill. But I'm placing the order if your lordship.
But grateful, my lord, I'm taking leave, lordship.
Yes. Page 46, blood. The petitioner alleges illegal and unauthorized construction at premises number V137/1 SA Faruqi Road, PS Rajabagan, Kolkata 7,18,000. The allegation is that construction is being made by illegally filling up a water body. On receipt of the complaint from the petitioner, departmental inspection was carried out at the subject premises. It revealed that no construction was noticed and no building material was found in the above mentioned premises. Photographs attached to the writ petition is in respect of premises number 137/G, SA Faruqi Road, where construction work was going on, and the department has taken steps against such construction. The construction at premises number 137/G was being made by deviating from the sanction plan. A stop work notice has been issued with intimation to the local Rajabagan police station. Learned advocate representing the private respondent admits that the construction is going on at premises number 137/G, and the same is being made in accordance with the plan sanction. Upon hearing the submissions made on behalf of all the parties, it appears that the subject premises is 137/G, where allegation is of unauthorized construction. The department has detected unauthorized construction and issued a stop work notice. The department is directed to take necessary steps to conclude the proceedings to deal with such unauthorized construction in accordance with law.
Yes, then what happened?
Yes, then, my lord, an order has been passed that we have been granted only one hearing. Certainly, my lord, this building has been regularized. Now, my lord, subject to, my lord, payment of payment of certain amount, my lord. If your lordship, my lord, kindly comes to page 57, my lord, the order of the special officer building.
Then
Page
that is an appealable order, isn't it?
It's an appealable order,
Yes.
but not no opportunity of hearing was given. One hearing was given. I agree.
Whatever, you can
Thereafter,
go and raise all these issues before the complainant. Please come. The petitioner is aggrieved by the manner in which the objection against unauthorized construction filed by him has been dealt with by the authority. Stop. The authority has proceeded to regularize the unauthorized construction upon payment of necessary charges. Stop. The petitioner is aggrieved by the same. Stop. The order of regularization is an appealable one. Stop. The legality and validity of the said order cannot be adjudicated in the contempt proceeding. Stop. In view of the above, the contempt application stands disposed of. Stop. It will be open for the petitioner to approach the competent forum for remedy in accordance with law if so advised.
Great.
But I put the petition on lordship. As per your lordship direction, I served the notice through the contempt, but delivery report is not available at site, lordship.
Why? Delivery report is not available.
Lordship.
Then serve afresh.
Lordship, kindly please have another date.
All right, please come. There is no proof of service of the contempt application upon the contemptor. Stop. Let further notice be issued. Release the matter on 14th August.
I am appearing for the petitioner.
I am for the respondent, my lord. Your lordship has gave liberty to the petitioner to make a representation regarding the salary.
My representation was deputed.
Considered, and because of this fact, my lord, kindly see this order. This petition has filed a writ petition before Honorable Justice P.K. Samanto, where he was one of the party. And by virtue of that order, he was regularized and absolved with effect from 1997.
Refusal order you can challenge in fresh proceeding.
challenge.
Please come.
Liberty only on the
Yes,
liberty
yes.
granted because the writ petition.
The petitioner's prayer for payment of area salary
Area salary and DA, my lord.
and dearness allowance
Dearness allowance.
to rejected by the municipality. Stop. আগেরটাতে যেটা বললাম না, legality and validity cannot be অতএব leave to file afresh.
Well, the order may be kept on the record.
Yes, order of the municipal
Liberty be granted, my lord.
liberty is granted.
Yes, to file it.
Contempt policing is done.
হ্যাঁ হ্যাঁ লিগ্যালিটি ভ্যালিডি থেকে হবে
Contempt is disposed of, madam.
disposed.
Get me.
82.
My lord, I am appealing for the alleged contempt, my lord.
Yes.
The Uttarpada Kotrang municipality.
Right.
I don't have the right to appear before.
My lord, once CEO was filed, my lord, arising from a statutory appeal, my lord. Section 218 West Bengal Municipal Act, my lord. My lord, there was a demolition order passed by the municipality, my lord. My lord, now the status of the CEO is not there, my lord. According to the CIS, my lord, the CEO is disposed of, my lord. But, my lord, no order communication is there, my lord. Even there is no record of the order, my lord, in the CIS, my lord.
When was this?
Partially complied, my lord, partially complied. But, my lord,
when was the CEO disposed of?
CEO is not disposed. I am handing over the last order passed in the CO and also the case status.
my lord, but it is not in the CIS, my lord. I will request, my lord, that to communicate, my lord, to the municipality. Otherwise, my lord, municipality could not take steps, my lord.
Lordship, there has been stay till the end of August. I have not no right to appear before your lordship, but I am the affected party. I have obtained the stay till the end of August from a coordinate bench of this honorable court.
Stay of what? Demolition proceeding?
Yes, lordship. Yes,
please come. Your appearance cannot be recorded. Learned, now it has been brought to the notice of the court that a coordinate bench of this court has been pleased to extend the order of stay of the demolition proceeding till August 2025. Stuff. Next, in view of such submission, hearing of the contempt application stands adjourned till 11th September 2025.
Grateful to you, lordship.
Deeply obliged, my lord.
এগুলো রেখে দিন।
I am for the contempt.
Item number 83 and 84, Mr. Shantiranjan Das is appearing in this matter. My lord, since he is not well, he has not been able to come to the court. I have been instructed.
Last occasion also adjournment was sought for.
My lord, I have been instructed to take not this.
So far as myself is concerned, man, I can submit before your lordship that we have completed the demolition.
All right.
Otherwise, I would have requested before your lordship, prayed before your lordship that a time may be given. I will file a compliance report. But I have instructions that I have completed my. I have completed.
Nothing is on record with you.
I have to. If your lordship so directs, I will file only some time may be given. I will file the compliance report. I think their prayer also.
Accommodation has been sought for on behalf of the learned advocate representing the petitioners. Stop. Learned advocate representing the contemners submits upon instruction that the unauthorized construction has been demolished. Stop. Next. In view of such submission, release the matter once again on 24th July. Stop. An affidavit of compliance shall be filed on the adjourned date.
I have a report to that effect, but I will file it by way.
Yes.
24th July.
I am for the private respondent in the writ petition. In the contempt application, I have not been met parties. My lord,
but since it is a contempt application, so there is no scope for you to appear.
But my lord, I have filed an application for addition because my lord.
In the contempt?
Yes. Because why I have filed, my lord?
Let me hear the petitioner first.
But one report was
no, my lord, one thing, my lord, I have already.
Still now the construction is there, my lord. No demolition has taken place.
Who is the authority?
The Pradhan is concerned.
Yes.
One Gram Panchayat.
There is a order of stay, my lord.
From?
Thereafter, from the division bench of this court.
All right, it is still.
The Pradhan has requested the SDO, my lord, in terms of that, my lord, to take accord necessary help with him, my lord, so that he can proceed with the demolition. But as of now, my lord, he has not getting any kind of, my lord, reply from the letter which has been given on 16th of June, my lord. And I have annexed the order of the division bench which has been
No, no, এটা পরে হয়েছে, পরে হয়েছে। Speech হলো, কিছু মানতে হবে না। অ্যাপ্লিকেশন ফাইল করেছো, অ্যাপিল ফাইল ওর লিভ অনুযায়ী, মান্থের লিভ অনুযায়ী লিভ দিয়েছি।
ওর নাম উপরে লিখেছিলাম, মিনালদার নামটা কি করছি? মিনালদার।
Earlier, a date has been fixed for demolition. Thereafter, they have preferred an appeal. Appeal court initially passed an order of stay, and subsequently, Milord, after that, Milord,
The appeal is dismissed, I see.
now,
Yes, appeal has been dismissed with leave to file an appeal challenging the first order passed by my lord. And I have filed the appeal with the leave of the to
dismissal of
file this without certified because file is with your lordship. Well, that appeal I have filed. Today I have, even today also I have mentioned before Justice my lord, division bench. My lord, lordship has been pleased.
Division bench.
no,
Appeal.
What
my
is your
lord.
lordship's parent order?
First order.
first order passed in 2022.
My lord, the appeal has been dismissed with liberty to file an appeal challenging my lord's order.
Yes.
I have filed that appeal.
Serving the liberty to the appellants as indicated.
7.
Yes, if the appellants were not served with notice despite when they should have either seek recall of the orders or single rightly dismissed as. Yes.
Subsequently, my lord, the order has been passed of 10th of June. On 17th of June, I have filed the appeal.
All right.
I have mentioned the matter before their lordships.
Are both the orders over here? Are both the orders in this file?
No, Milord, only your lordship's order is here, Milord.
Earlier order?
Yes,
Yes, yes, certainly,
is
that
the
will be
contempt
there.
application. Page 80, Milord.
80?
80 of the content application.
Yes.
Page 81, Milord. Respondent number 5 and 6 are directed to consider the representation filed.
Yes, it's a mere consideration of the representation order. Then?
Thereafter, Milord, the Panchayat has passed the order for demolition.
Right.
No, initial order for cancellation of the sanction.
Cancellation of the sanction.
All right. Then?
Challenging that order, my lord, I preferred a writ petition.
You preferred?
Yes.
Yes.
My lord, writ petition was disposed of,
Huh?
rather dismissed by holding that since I have not preferred any appeal challenging my lord's order, and my lord, the contempt proceeding is in session.
Where is that order?
My lord,
Thereafter, they have preferred appeal.
Challenging.
Challenging.
Let me see that order. Where your writ petition stood dismissed?
This is
এটা তো ফার্স্ট অর্ডার নাকি?
হ্যাঁ? না, না, Patnaik. It is before Justice Patnaik.
You said this bench passed order. This is the reason I was wondering which order could have been passed.
His lordship passed in 2022 by direction was given to consider.
Only to consider
Lordship.
that the issue is very much live before you undertake the contempt
But
matter.
see-
It's been informed.
The division bench is of the views that since the order passed by your lordship was past expertise in my absence, I could not get the opportunity.
All right. Assuming it is an ex parte order, but there was a direction possibly for consideration of
Yes,
hearing of
consideration of the
parties.
representation. If that be so, my lord, after consideration matter,
After giving an opportunity of hearing to all the necessary parties.
my lord. Well, the point raised by before this court is that section 23(5), my lord, Pradhan has no authority to pass any order of demolition because the SDO is the authority. According to the division bench, my lord,
I should,
Admittedly, the Pradhan does not have any authority.
Mal.
It is the SDO.
Mal.
Legally, it is all right.
if the entire matter is shifted to the SDO, my lord, I have no objection to that.
Yes.
My appeal, I have not required to be proceed with the appeal. But
Exactly.
entire matter is required to be placed before the SDO.
So what is the Pradhan doing?
My Pradhan has first, my lord, he has,
His lordship's order, my lord, to.
What order?
Pradhan has cancelled the sanction plans
Yes.
by a non-speaking order only by
Right.
saying that all the documents has not produced before him.
Yes.
My lord, that order I have annexed, my lord, in my application for addition of party. Now, that is at page.
Affidavit on behalf of the alleged contemner. What does the contemner say to the position of the plot? How has the consideration been made? Was
Kindly
opportunity of hearing given to all the parties?
Page 70, my lord, my lord. I was there.
You were there.
I produced the.
Now, where is the order of the
Page
Pradhan?
70 of my application for addition of party.
Application for addition of party. Where is that application? Where is that application?
কাকে আমাকে আমার কাছে ও তাহলে প্রধানকে দিয়ে আমার কাছে আসে এসে পৌঁছয়নি
দিয়েছি এখানে তোমাকে তো দিয়েছি অ্যাডিশনাল পার্টি দিয়েছি সবাইকে দিয়েছি সে কত দিয়ে দেবো
Where is the can?
Can?
Can of the contemner? Where is the compliance? Let me see.
Two affidavit has been filed, my lord.
Two affidavits
Yes, my
have
lord.
been
If it's
filed.
Next affidavit, my lord, that has been affirmed on, I just put the date, my lord. 14th of November 2024, my lord.
Yes.
My lord, in page 4, my lord.
Yes.
Lines of the order, my lord, this is to inform you that applicant so-and-so has not come up with a clear and did not disclose the correct fact and the documents which has been submitted to us contrary with each other. Accordingly, the sanction plan has been granted earlier, that is on 4/12/2020, is cancelled with immediate effect. Thereafter, my lord, my lord, the Pradhan, my lord, in terms of his lordship's order, issued notice, my lord. A date has been fixed on 18th of March 2025. That has been, I have been handed up to his lordship. Date has been fixed for demolition.
How could the this
As
is where the problem lies?
arises.
How could the Pradhan issue an order of demolition? Pradhan is not the authority.
He has not proceed. Thereafter, my lord, the stay order has been passed. After this vacating of the stay order, my lord, he has wrote a letter to that I have given to his lordship.
Where is the file now?
The file is with the SDO.
Has the file reached the SDO? Who has forwarded? Oh, Pradhan has forwarded to the SDO.
Yes, my lord. This is the last letter which I have given on 16th after
16th
the
of June.
vacating of the 16th
Now
of
the file is there before the SDO. Let the SDO consider the entire thing.
lordship.
My lord, may I get a copy of কি পাঠিয়েছেন একটু দেখি না
এই তো SDO কাছে
না কি লিখলেন তাতে
তো বলেছে যে আমাকে তুমি এ দাও আমি for the purpose of demolition to comply the order of the court.
I am under contempt being
Yes.
such and such. Urgent instruction is solicited for demolition. Well, it has not mentioned that the entire file has been sent to the SDO.
But
Only letter has been given.
No, the file will go.
How the
Please
SDO
come.
will consider that?
Please come. The matter relates to unauthorized construction. Give me the application for addition. Jana Babu. Unauthorized construction. Stop. It appears that the Pradhan has come to a finding that the plan was not sanctioned properly. Stop. The Pradhan has sought instruction from the subdivisional officer with regard to demolition of the subject structure, which is alleged to be constructed unauthorizedly by the petitioner. Stop paragraph. According to law, Pradhan does not have the right to pass an order of demolition. Stop. The Pradhan is required to forward the entire file to the subdivisional officer for taking necessary steps. Paragraph.
May I interrupt one thing, my lord? My lord, unauthorized illegal concept is different. My lord,
Yes.
in my case, I made the construction as per the sanction plan.
You
Subsequently,
go there before the SDO and you place all your points. Acha. Paragraph diye. The learned advocate representing the Pradhan submits that the matter is pending before the subdivisional officer, Canning Town. Paragraph. The as the now from the communication of the Pradhan dated 16th June 2025 being memo number it is not very clear as to whether the entire file relating to unauthorized construction has been forwarded to the Pradhan or not. The Pradhan is directed to forward the entire file dealing with unauthorized construction to the subdivisional officer. Stop. The subdivisional officer, stop now, who shall give an opportunity of hearing to the petitioner and the person responsible for making unauthorized construction, namely Biplab Noshkar and others. Right? After hearing both the parties, the subdivisional officer shall take steps in the matter in accordance with law. ঠিক আছে যেখানে প্রধানকে পাঠাতে বললাম it should be within 1 week from date না 2 সপ্তাহ করে দিন within 2 weeks from date shall forward the entire file within 2 weeks from date. Our SDO will act within 8 weeks from the date of receiving the file from the Pradhan. I'm disposing of the contempt.
SDO will send a hearing notice.
Absolutely. That is the direction. The contempt application disposed of, application for addition of party, filed by
Biplab Noshkar and others.
Stands disposed of accordingly. You are saved from the appeal court.
What I prayed for before the appellate court, that has been done by me. I'm getting grateful.
Illegal.
86. Yes.
On the contender matter, in this matter, the occupant has filed a writ petition and got a interim order that they have not been heard. Stay of this coordinate bench. Recently, yesterday also, Honorable Justice Gaurankant has extended the interim order till for 7 days, but we have not heard them.
These are the orders. It's
We have
not
not-
by occupier, it's by owner itself.
Whatever.
Petitioner.
So,
the order
are you aware of
complied? It gave original cause of action in their presence.
Please wait. Are you aware of the order of the coordinate bench?
In their presence, it has been passed.
What?
Complaining the violation of my lord's order, I have filed this contempt.
Yes.
My lord's parent order says that an inspection to be made and that
Do not repeat things. There is huge shortage of time.
Yes, may I only say.
There is an order which has been passed by the corporation in compliance of the court's direction. That order is under challenge before a coordinate bench and an order of stay is passed. I'll adjourn it.
They are parties in that. In their presence, stay was granted.
Their ground in.
Whatever their ground is
One
before
thing
that case, before that court.
Kindly have a look to the
Their
order.
only ground that the corporation has not obeyed my lord's direction of serving the inspection report and giving hearing prior to passing of the order. My lord is in contempt of my lord's order. If that is so, kindly set aside the demolition order from here now. Kindly fixes a date for spot inspection,
Yes.
passes direction for service of that, and fixes a date for hearing from here. Otherwise, they will again come that they have not been served. Their advocates are representing.
That will be a better order.
Yes.
Kindly have.
This will continue.
Yes.
Otherwise, my lord, occupiers will come again. Now occupiers will come.
It will go on for a
Possibly,
This will go on.
kindly have a look to these two
Copy
orders.
the order of demolition.
My
But kindly have a look to these two orders passed in the new writ petition.
This is a very good
Show me
suggestion.
the order of demolition, please.
I beseech your lordship, my lordship, pass that order. And then we will be very satisfied.
Now,
must be in record.
আমাদের read
Is it in record?
Yes, must be in record. It has been.
may I give you a lordship, my
26th
lord?
of March. All right.
Though the order is not well reasoned.
Please come.
এটা copy দেবে
My lord, my lord, if your lordship may kindly allow me one
The
minute.
A very dangerous order.
the order passed by the Howrah Municipal Corporation,
ঠিক কথা।
শেষ হয়ে যাবে।
আমাদের পক্ষে অসুবিধা হয়ে
allegedly
যাচ্ছে।
It will be hard.
in compliance of the direction passed by the court.
This gave me a cause of action
Acha.
for which, my lord, it was heard in another writ petition. And in presence of all
Column.
parties, it was stayed hearing fixed.
The order of demolition. The order of demolition.
এই নাম দিয়ে।
Passed by the Howrah Municipal Corporation allegedly in compliance of the direction passed by this court has been challenged by the aggrieved party in a separate writ petition being WPA 9303 of 2025. Within bracket Pramod Kumar Shaw versus Howrah Municipal Corporation and others.
আছে আমার কাছে।
Stop paragraph. The
Lord, kindly have a look to the order, my lord. These are two orders passed in their presence itself. It gave me a cause of action because I am not a party in contempt.
sir, I have seen the order. I am looking at the order.
I'm sorry.
Please do not make submission.
Kindly.
19th of June and certain just. The ground for challenge in the writ petition as appear
ওটাও তো উঠে যাবে।
as appearing from the order dated 19th June 2025 is that the writ petitioner, that is Pramod Kumar Shaw, was not heard.
My lord, there were other directions also in your lordship.
Does it require the inspection? And the inspection report was not supplied to him. Stop paragraph.
This is the original order, my lord.
The learned advocate for the petitioner submits that the petitioner petitioner in the contempt petition submits that the petitioner does not have any objection if the authority is directed to give further opportunity of inspection and hearing to the person responsible, and thereafter the corporation may pass necessary order. Stop.
He is not the, my lord, I'm sorry, he is not the person responsible. That is, they are coming. He is the landlord.
Whoever it is.
Any person who is interested.
Yes.
I am owner of the property.
Kindly indicate, my lord, respond number 6 to 9 in the writ petition. It will come.
6 to 9, my lord.
6 to 9 in the writ petition.
Then again, it will cause us
Because
confusion.
one of them has come up, my lord, by filing the another writ petition. Tomorrow the second will come and thereafter third.
There are three orders, 6 to 9.
Yes,
6 to 9.
should be heard.
Everybody will be heard. Yeah.
Acha. The learned advocate representing the corporation / contemner is agreeable to the
Agreed.
proposal made by the learned advocate representing the petitioner in the contempt petition. Stop. Next. Accordingly, the
They say that the impugned order can be set aside with this, which has been furnished in the contempt proceeding. They say, my lord, this can be set aside, which
Acha.
is ground in
Accordingly,
that
কাটুন আপনি লিখুন Vide order dated 31st July 2023, the court specifically directed the corporation to conduct fresh spot inspection upon giving prior notice to all the necessary parties, serve the spot inspection report to all the parties and give opportunity of hearing to all the parties, and thereafter pass the final order. Stop. The said order is directed to be complied with by the contemner. Stop. The hearing of the contempt application stands adjourned till 18th of September.
As your lordship.
It is July now. 18th of September.
Milord, should it be kept pending or it can be
Fixing after 2 months and my lord giving full time. Kindly fix the date for a spot inspection from here.
No.
Otherwise,
That will do. That will do.
My read will go, original cause of action goes.
Point that they have not been
No,
served.
clear করে, clear করে
Take
দিচ্ছি।
away the right
Clear
of
করে
the
দিচ্ছি।
party.
এক মিনিট clear করছি।
This will go
But
on.
only one thing, my lord, that I don't know whether they will accept or not. We will also affix a notice in the conspicuous place of the site.
This is in addition.
That will be addition.
That can be in addition, not Milord, the substitute of that.
No, no.
The
Now I apprehend that they will come.
I do not stop Milord, but that must be in
notice of spot inspection and hearing shall be affixed at
As your lord.
various conspicuous places in and around the
My lord, my lord,
disputed structure.
my lord.
Stop. Will you accept, will your on record accept notice?
There are 3 private parties.
Yes, very
You
good.
are representing all?
All
In respect of Pramod, who is the read petitioner, there are 3 owners. May I just, I do not know what is the reason to laugh. There are
Sorry,
3 owners of the property. One has filed the read petition. I am representing Pramod Bajaj. I can receive on behalf of Pramod. So far as other 2 owners are concerned, they will give a notice. They can also give me Vokalatnama and I can appear, of course.
No, whether they will give wakalatnama or not is up to you and your client.
Till now, I am not
Neither the
representing
court nor they are there.
Till now, the read is only by one of the brother owner of the property.
6 to 9 was duly represented by learned counsels in the writ petition. Now a separate counsel has been engaged.
Yes, my lord.
You never know whether you'll be there tomorrow or not.
No, my lord, that
So you nothing doing?
I will appear for Pramod, but so far
I do
as
not know whether you appear for Pramod or somebody else.
if they have authorized, I can always appear, but I have to.
no, that will do, my lord. If I affix
Let
it,
them give
that will do.
I will appear.
That will be a sufficient notice, I think.
Let them serve.
For that reason, I prayed before your lordship
Yes.
that will be affixed in the conspicuous place.
Next.
That it is creating many problems.
May I submit, my lord, that with great
Kindly
respect.
record their appearance
My
at
lord,
least, my
my
lord.
lord, may I submit one thing that
Kindly record their appearance at least, my lord.
I am
Please
not a
appearance.
party actually in this, but
Very
Mr.
well.
Mohendra Gupta is appearing for the promote.
Pramod Kumar Bajaj, yes.
আচ্ছা।
The read petitioner is
যেখানে
WPA number.
যেখানে বললাম না WPA নাম্বারটা
Pramod Kumar Sao
ভুলে গেছি।
appearing in WPA
নামটাও বলে
9303 of 25.
পার্টির নামটাও বলে দিয়েছিলাম।
Point number 8 in the writ petition before my lord.
না না ওই রিট petitioner আমি ওই রিটে আর কি একই ব্যাপার of course he is a
বলেছেন
private
তো?
party.
আর
এই নাম দিয়েছেন নাকি?
উপরে যে অ্যাপিয়ারেন্সটা লিখবেন সেখানে number 6 in the writ petition.
The read petition.
In petition and petitioner in WPA 9303 of 25.
And petitioner in WPA number
9303 of 25.
এই উপরে যে নাম্বারটা
9303
Very
of
well.
20.
Yes.
Lord, may I pray, my lord, that since your lordship's order was that they will pass an order and after filing of the contempt about 4-5 months after they filed the my lord compliance report before this court, since that compliance report gave me a cause of action, I approached by filing it.
Will you please tell me what is your prayer without going
May I
into all
submit
this
that the
history?
contempt may be disposed of.
Contempt may be disposed of. This is my order and the court will decide what to do. You are not a party in the contempt even and you want the contempt to be disposed of.
I'm sorry.
My returnable date on?
Yes, it's in September, 18th of September.
18th of September.
Great.
Grateful.
September.
87.
I am for the respond number 10 in this matter, virtually appearing.
All
Along
right.
with Mr. Mohammad Jawad.
The police
Yes. Order complied. Who is for the petitioner? Oh, the court in its own motion. All right. What is to be done now?
It is yet not been demolished in total.
Not been demolished.
Floor has been demolished.
How many floors are there?
There are, I think, four floors.
All unauthorized. Entire structure is unauthorized.
It was.
My lord, there are 333 buildings
there
are
were,
there in the entire block.
What
as
are you
there were-
handing over?
Lordship, there is an appeal preferred.
Yes,
Let me see.
an appeal has been preferred.
The appeal has been preferred, my lord, that has been tagged with the original public interest litigation, where 333 house has been considered by their lordship, the Honorable Chief Justice and Justice Chaitali Chatterjee Das. It has been tagged together with the appeal should be heard along with that appeal.
I didn't get it, sir. This appeal, is it arising from this proceeding which is pending before this
This
court?
proceeding, but my lord, regarding the Shantinagar, the Honorable Chief Justice has formed that the public interest litigation
That
should
is
be
something
heard by that
different.
bench.
The public interest litigation, there is a bench taking up that matter and the bench will continue.
No, that matter specially assigned to the as a specially to be heard by Honorable Chief Justice.
Yes,
That
the
is
bench
there,
is
and
heard.
along with this matter also been considered that this matter also been taken up because along the 333 flat.
Where
this
is that
flat,
order that this file will go over there? I'll send it merrily.
No.
Where is that order?
My lord, then kindly adjourn. I will mention it and then pass. I will request the Honorable
Yes,
Chief Justice
please.
to pass the
There
necessary
is no
order.
such order as of
Such
now
order,
to
yes.
send this file
Right.
for my lord the Chief Justice. My lord, there are two public interest litigation pending
Yes.
where the Honorable Chief, the PIL bench was, my lord,
Right.
seen over few of the illegal constructions in ward number 35 and 36 of the corporation, my lord. And my lord, this writ petition, this appeal was filed, my lord, and my lord the Chief Justice was pleased to tag this with one of the public interest litigations, my lord, which was dealing with the same thing, my lord. And this appeal arises out of the this particular matter, my lord, and the premises, my lord, we are talking about, my lord, falls within the purview of the said public interest litigation, my lord, admittedly. This is the scenario. However, my lord,
How
there
many-
is no stay.
How many floors have you demolished?
We have demolished one.
One. When?
A quarter flat baki hai.
When did you demolish?
My lord, we have demolished 3 flats on the top floor.
When?
And my lord,
9th of April.
yes. And on the last
Adequate
occasion,
police team gathered in this spot.
last order.
The officials vacated only 3 flats among the 20 flats occupied of the alleged G+4 storage. Where is the photograph? Show me the photograph.
Occasion we had.
Photographs were filed.
Yes. My lord, right now, my lord, I'm sorry, my lord, I'm.
Earlier day, the photographs were filed along
Last
with the
occasion, my lord,
virtually.
but I'm saying-
Along with the minor.
This is the
email.
photograph from the police. Right, sir?
When is the next date of demolition?
Lord, we have not fixed it as yet. We have
not been given any requisition.
No, we are not
But
making.
then what are you waiting for?
Milord, as this was tagged with the PIL of Shumon Das, Milord, WPA 2 of 2020, Milord, we were just, we just went a bit slow, Milord. We wanted the courts to direct us to that effect. Because, Milord, it involves a lot of other people as well. That is the only reason, Milord. I would be absolutely.
But there is no order as
stay.
of now.
There is no stay. There is
Then
no stay. Milord,
what can they do?
we will fix a date, Milord, within a week then thereafter. And as the state is here, Milord, the state will ensure a vacating of the house, we will demolish.
They make a requisition to the police.
My lord will fix a date here and now, Milord. The police is here. The police will ensure the vacating of the house, we will go and demolish.
No, we will give the police force.
No.
Please come. The unauthorized construction is yet to be demolished. Stop. No order from any competent court has been placed before this court staying operation of the order passed by this bench. Stop. Under such circumstances, the contemners will be bound to comply with the order passed by the
Subject
court.
to correction, we are not the contemner in this matter.
We are not also.
Nobody is a contemner.
Milord, here, Milord, the court on its own motion, Milord, took up the contempt because the
Alright.
developer was directed to pay rupees 1 crore, Milord, which they perhaps had not paid.
All right.
So this is, we are not the contemners, Lord. We will be complying with the order.
There is an order of demolition
Milord, there is. Milord, we are,
passed by your authority.
Milord, we are not saying that we will not demolish. They are saying we are not contemners.
লাইনটা কি বললাম না না আগে ফার্স্টে শুরু করলাম অর্ডার অফ দি কোর্ট placed by this court staying operation of the order of demolition. Now, the authority will be bound to execute the order of demolition. Stop. The hearing of this matter stands adjourned till 21st of August 2025. Stop. The police shall be responsible. Now, একটা লাইন লিখুন from the report, from the action taken report signed by the engineers of the corporation on 9th April 2025, it appears that on 9th April 2025, 3 vacant flats on the top floor of the G+4 storied building
On 9th April, we have received the bill. Replied.
were demolished by the demolition team of the corporation. Stop. There are 20 occupied flats in the building, which is entire in the G+4 storied building, which is entirely unauthorized. Stop. The police shall be responsible to remove the occupants by using reasonable force in the aid of demolition of the order passed by the corporation. ঠিক আছে রিলিস্ট তো বলেই দিয়েছি Very well.
9th April bail we have replied on 10th April.
ঠিক আছে Obligement. 21st August.
Online they've added, but at least 7 days time may be given to by the police so that we can arrange for a force. Just one line added. Just one line maybe they will intimate the date so that you can arrange for a force.
The corporation shall intimate the police at least 7 days in advance the date of demolition.
Milord, there is a difficulty, Milord. If what we will do, Milord, subject to correction, we will write to the authorities that once it is vacated, we will demolish it the next day.
Sorry, sir, I do not accept your prayer.
Milord, if we fix
I
the date,
am not accepting your prayer. Next.
Milord, in item number 88, Mr. Mondal is representing the contemners.
Yes.
Milord, he is being instructed by the learned advocate on record, Mr. Shobik Das. Milord, he has suffered an accident and for which he is bedridden now.
Who?
Mr. Shobik Das, the learned
Alright.
advocate on record. So he will take at least 2 weeks time more to come to chamber. So if your lordship can take up this matter.
I do not understand the prayer that you are making. The on record has met an accident.
Yes, yes.
What has he got to do?
My lord, he is contacting with the client and he is instructing.
All over telephone. He is not going there directly, isn't it?
No, no. Regarding
Then where is the difficulty?
he is not even coming out of the house at present.
No, in February, the order was passed for a compliance report to be filed, and we are in July.
It has been served also.
Yes.
It's been prepared, but subsequently certain developments are there, which is to be placed on record, and he needs to come.
What is his submission?
On 20th February 2025,
yes,
are passed by your lordship My lord, paragraph 4, page 2.
Yes.
My lord, on that portion, my lord, they file an advance copy of affidavit of compliance. But this is my lord, not
It has not been
uh,
placed on.
the advance copy. Kindly have a look into 2 or 3 pages, my lord. This is my copy, my lord. My lord, they kindly have a look into that.
You tell me what is there.
They determined illegal and directed the private respondent, you demolish 10 days ago. Thereafter, 4th month, nothing has happened, my lord.
Please come. Though the original affidavit of compliance has not been filed by the learned advocate representing the contemner, but a copy of the same has been handed over to the court by the learned advocate representing the writ petitioner. Stop. It appears therefrom that the chairman of the municipality has come to a preliminary finding, that the construction has been made without obtaining a proper sanction plan.
No sanction plan. Proper.
অত্র পৌরসভা হইতে বৈধ অনুমোদন ছাড়াই আপনার বাস্তু নির্মাণ করিয়াছেন, সুতরাং আপনি এই নোটিশ পাওয়ার 7 দিনের মধ্যেই। আচ্ছা, it appears that the chairman of the municipality directed the petitioner, the person responsible, to self-demolish the unauthorized construction within 7 days. Stop. According to the West Bengal Municipal Act, the order of demolition ought to be passed by the Board of Councillors and not by the chairman of the municipality independently and unilaterally. Stop. The chairman of the municipality is accordingly directed to place the matter before the Board of Councillors for taking steps against the unauthorized construction in accordance with law. Release the matter for further consideration on 21st August 2025. Stop. The original affidavit of compliance and the further steps taken by the contemner in compliance of the order passed herein above shall be placed before this court on the adjourned day. Take this back.
Copy, my lord. I'll hand over.
No, he'll file the.
Only one thing. If your lordship can indicate, I could not file the original because of the physical inability of the learned advocate on record. My lord, otherwise it would be difficult for him.
Why shouldn't the copy be with you?
My lord, it's with him at present. So there is a difficulty, my lord. He underwent an operation.
আচ্ছা, লিখে নিন একটা জায়গায়। The learned advocate representing the contemner submits that the original affidavit of compliance affirmed on. Please check the date and tell me. Could not be filed as the learned advocate on record.
April 2025.
As the learned advocate on record has undergone a surgery and is indisposed.
Deeply.
Inner appearance never. Please enter your appearance. Please enter your appearance. Your appearance.
Yes, ma'am. Yes, ma'am.
I am appearing for the contemner, Your Lord.
Yes, please. Has the order been complied?
Yes, Your Lord.
Yes, Lord.
Complied. We have transferred to the report.
Just now I have handed over with a copy of the compliance, my lord, as it appears from paragraph number 3 that the concerned Pradhan the Panchayat has found the structure to be illegal and that matter has
Not
been
illegal, Lordship, it's irregular.
without
Irregular because there is a sanction plan and that has been affirmed by the earlier board.
Had there been
And the Nirman Shoyak has, in a inquiry, has clearly stated that there was a sanction plan issued by the earlier board. He has already affirmed, Your Lordship, to that effect that it's his signature.
Had there been
Lordship kindly comes to
permission, Lordship, then post facto sanction.
no
not
post
been
facto. We
given.
are not talking about post facto. Which, as per what my lord has.
After passing of my lord's order and post facto
It's no approval. We have already transferred to the SDO, Lordship. Kindly, if my learned friend allows me to submit, then I can apprise with my lord about the present facts. Your Lordship.
Kindly take up the order.
Lordship, kindly comes to page number 14 of my compliance.
You got this just now?
Just now I have.
Very well. Compliance report affirmed on 18th June 2025 has been placed in court today. Stop. Copy of the same has been handed over to the learned advocate representing the petitioner today. Stop. Learned advocate for the petitioner seeks time to take instruction. On such prayer, released on 31st of July.
We have already reported to the SDO, Your Lordship.
Why? You have mentioned everything in your compliance report. Why will the court record it all over again?
The decision, appropriate decision, Miller, we will send it up
All right.
government for necessary.
And then what is to be done over here?
The 2 pages they have sent.
Yes.
This cannot be the measurement book. This cannot be the measurements. It can see what is this.
COH chairman, as per the order, inspection was carried out. Estimate holds the value such and such.
This is their own calculation. They have.
This is the measurement book for all tenders we have.
Cannot be. Well, length, wide, everything should be there. But if there is a construction, it has to be find out by taking the.
And it is mentioned that measurement was taken in presence of all the interested parties. Pintu Dey has signed it on 24th of August 2023.
Against whom
who is this Chandrajit Chakraborty?
Chandrajit Chakraborty is another not from the department, because he was called in to sign because he was there in the inspection. Not independent. He is another engineer of the municipality.
But is it the
As it is
measurement
included.
book? This cannot be.
This is certainly not a measurement book.
Yes.
Measurement book has a specific format,
Yes.
and all measurements are recorded over there. This is something you've copied from somewhere and you just typed it
Yes.
and
Milord,
placed it.
Milord will take up the next page, Milord.
Yes.
Calculation, everything's are there. Nothing is there. Length, wide, depth. Where is those? A book should be there. This is their prepared document.
No,
Milord,
it does
I
not
had
appear to
taken-
be proper.
Milord, I had taken an instruction, Milord.
Yes.
Generally, they do it like this in pages because measurement book is not given to the, it is not a document which is provided to the bidder. It is with the
Authority.
authority.
Yes.
It is even in the Bidhannagar Corporation or
Yes, yes,
it
it's
is.
always with you.
This is the way, Milord, they maintain it.
How are you maintaining? Where is the maintenance?
Milord, the
Where are the
measurements, Milord,
measurements
will
taken?
see. Milord, the measurements are there, Milord, but it is the way they have.
Where is the measurement?
Milord, we'll
Please
see
show
the
me.
first page, Milord. The total
Yes.
length of the road calculated in 5 numbers of estimated the construction of concrete road from flyover to Belting Bazaar, Milord. And this is the measurements which has been there.
This measurement cannot come one after the other, plus, plus, plus. You make a measurement on a day, you put a signature and the date. Then next day measurement made, you put a signature and a date. See, this you have copied from somewhere and have placed it.
Milord, we can.
Where from does he
original.
get the record?
Milord, we can bring the original.
Do not bring. Where from did he get? 109M? Where from did he get? When was the measurement taken?
Milord, I will seek instruction specific, but Milord, this is the, I had specifically asked them that why it is like this, Milord. The format may be wrong, Milord, but they do it for all matters.
Just take it. Assuming 109 was measured in one day.
Milord, I have got the point, Milord. I have absolutely got it.
124 comes the next day.
Milord, I have asked the same question.
Obviously.
How to justify or how to explain it to somebody who is not a party to this.
Exactly.
Milord, the answer, Milord, which has fallen from, Milord, was that I have told them to restructure this. I have already advised them that take proper instructions and proper help from the other authorities and restructure this. But Milord, this they have been doing, rightly, wrongly, Milord, this has been done without any malice. That much I can say.
There must be a book. Date is to be maintained.
But then all
Details of
things
the
said and done, what is to be done in the contempt right now?
Because of this, not the sins, they have wrongly stated that their certificate is wrong. If your lordships kindly come, the certificate I have annexed in the
There was a reasoned order passed.
Page 34. 34 onwards.
Where is the reasoned order? Is it communicated?
But last time, Milord, we had provided in the annex.
Report in the they have stated report.
Where is it?
Report page 33.
33. Have you annexed it?
In the contempt petition.
Yes, yes.
Region order they say page 30.
Region order. These are not under challenge. Sir.
What is the order passed by the court?
Yes, lordship's page 20.
If the petition
If the relevant person 21.
Decide the prayer. I will not go far. Please come.
Not page 30. Not lordships can go.
The petitioner alleges that the order of the court has not been complied with in the proper manner. Stuff.
Page 32 lordship will go.
It appears that the municipality, now the chairman, has passed an order in the form of a report requesting the petitioner to accept certain amount which the petitioner is not agreeable to. Stop. Paragraph. Whether the figure indicated by the municipality is proper or not cannot be ascertained in the contempt jurisdiction. Stop. It will be open for the petitioner to challenge the direction of the municipality in a fresh proceeding. Stop. The contempt application stands disposed of. The municipality is, however, directed to take proper steps against the erring officer engineer, sub-assistant engineer, who is reported to have admitted his guilt and sought for forgiveness. Contempt application stands disposed of.
Lordship can go through
Do I take that document back?
Which document?
The document I handed over.
This one. Let it remain with the records.
May I get a copy of that?
What?
That is not his concern at all.
What?
Somebody else.
What?
Page 32, very next day, they asked the petitioner, if your lordship go through, they say that at 17:10 hour at the evening, at 5 p.m. they called the petitioner at his chamber.
Yes, yes, you challenge it. আচ্ছা এরপর কি আছে? সকালবেলা দুটো মেনশনিং হয়েছে? কল
362 item number 362.
I am for the contempt petition. The issue is that demolition of the illegal construction. After 3.5 years, by virtue of the order of this court, the contemner started the proceedings and declaring it is illegal construction. And
1 minute. 20,000 rupees has it been deposited with the BDO?
My lord, these are the receipts, my lord.
All right. BDO shall utilize BDO. I'll take care. The receipt showing payment, the petitioner granted leave to follow up the matter with the SDO. Did you follow up the matter with the SDO?
Yes, my lord.
Let the SDO take necessary steps. What is to be done now?
Affidavit in compliance also, my lord.
Now, what is to be done in the contempt? It will be disposed of.
My lord, we have complied to your lordship's orders, man.
The correct position is that the matter remains as it is. Because
now the SDO, you have to follow it up with the SDO.
SDO is not taking any steps. We making the representation. We have supplied all the documents and everything, but there is no reply. And unless this matter, unless SDO be present before this court.
No, SDO is not a party. How can the SDO be directed to remain present? Who appeared for the state respondents in the writ petition? Did anybody appear?
No, my lord.
Nobody appeared?
No. On the last date, nobody appeared. It was contempt application.
No, in the writ petition.
Writ petition to order writ petition ke dari. No,
Nobody was there for the state.
Nobody has appeared.
আচ্ছা একটা কাজ করুন, রিসিট গুলো কোথায়? হ্যাঁ, পিটিশনার কমপ্লেন্স কেন দিল? ডাইরেকশন ছিল না, কেন দিল সেটা আমি পরে বলবো। আচ্ছা, the receipt, the original receipt of the duplicate carbon receipt book dated 25th June 2025, showing submission of rupees 20,000 each by the contemners, filed in court today, be written with the records. You have photocopies?
Yes.
Stuff. Let a notice be served in the office of the learned government pleader for engaging a learned counsel to represent the block development officer and the subdivisional officer. Stop. The affidavit filed by the petitioner in court today is taken on record. It appears that after noticing unauthorized construction, the Pradhan has forwarded the file to the subdivisional officer. Stop. The petitioner alleges that the subdivisional officer is not taking any follow-up steps. Stop. Next. Release the matter for further consideration on আজকে 3 তারিখ তো 17th of July 2025. Learned advocate representing the state respondents shall obtain necessary instruction in this regard. Keep these two on
Madam,
record.
the Pradhans are released, madam.
Yes. Are they present?
It was not directed, my lord.
Yes, then it's all right. You remain present.
I'm great.
What is the other matter? Konta? It was mentioned and nobody is here.
401 was mentioned.
401?
For travel application.
Yes.
That we have mentioned.
No. One.
আচ্ছা ঠিক আছে 5টা রাখুন 401 দিন. Similar order was passed in respect of what Kalodia.
Another person, my lord, whose application we have withdrawn. The earlier application on the ground, my lord, the travel time at that point of time expired.
So?
And my lord, the person for whom your lordship was kind enough to grant us leave, my lord, he has come back. We have prepared a supplementary affidavit, my lord.
For this Sujit Kanodia?
Well, that was in respect of my lord. Now we are praying for my lord.
Sujit Kanodia, we have prayed for Raghav.
Raghav Raj has come back, my lord.
All right.
Now, my lord, Sujit now wants to go, my lord, for his medical treatment.
And also wants to visit his daughter. This is the itinerary.
My lord, itinerary, your lordship will have, my lord, at page 7.
And the order.
But if I just show your lordship's order, my lord, page 5.
Yes, Raghav
Page 6 will be.
Sujit Hari Prasad. Did you serve notice? Are you there?
Well, the union.
The
Union of India.
All right.
I believe it is also
It
there.
is
They
also
have
served.
served the notice.
They have been served. Where are the tickets?
My lord, tickets we have not booked, my lord. Page 7 is the itinerary.
Itinerary is your itinerary. You never know.
My lord, we have given an
Very.
my lord, which was lacking last time, my lord.
No, last time I can remember distinctly the travel tickets were there.
Tickets.
Where are your travel tickets?
But we have not booked as yet, my lord. Because I tell you, lordship, this petition we had to cancel. Since, my lord, we wanted to move it at a particular point of time, your lordship was not, I mean, your lordship was in the circuit.
Somebody was there.
No, but it was refused, my lord, on account of urgency. We could not do that just before vacation. So we had to cancel that, my lord. International tickets, my lord, is very
Traveling from Delhi to London.
and then, my lord, from
15th
London
of
to
July.
New York.
Today is 13th.
My lord.
Leaving
Today,
for
third, my lord.
third.
Third.
Right. 15th, 16th, 23rd, 24th. Where will the medical treatment be done?
My lord, in Boston, my lord.
If it is in Boston, why all the way you are going from London?
My
And
lord, London, the daughter is there, my lord. He will meet the daughter. Then
so there are multiple reasons.
no, the main,
Not only
my lord, main reason is, my lord, the treatment, my lord. He was earlier treated there, and coincidentally, my lord, earlier he met with an accident when he was in Boston. Then, my lord, he was treated there. He was in coma. Then there are multiple
Whatever.
operations done.
But then, had the tickets been here, then it would have been.
My lord, tickets we have. Your lordship may record our statement, my lord. We have not booked, my lord, because without taking the permission, we thought it will be an audacity on our part, my lord, to book the ticket beforehand. And my lord, we have undertaken, which was lacking last time, as pointed out rightly by your lordship, my lord. Page 2, para 5, my lord, in the supplementary. That undertaking was not there, my lord.
এই তো এখানে রয়েছে অর্ডার দিয়েছে
To be very honest, my lord,
4, 5,
I
7,
have seen,
7.
my lord, sometimes the honorable judges take umbrage of the fact that why do you book ticket beforehand in anticipation that I'm going to allow your prayer.
Yes, yes.
So which is why, my lord, we
5, 7,
have not
7.
booked in this case.
Um,
If the similar benefit be extended, my lord, as your lordship was gracious enough to extend my lord, another petitioner at page 6.
please come. An application has been filed by Sujit Kanoria,
Most obliged, madam.
disclosing his travel plans to go abroad. For medical treatment. In Boston, USA. Stuff next. The petitioner has disclosed that he'll be traveling from Delhi to London. Does he stay in Delhi?
He's staying in Delhi, my lord.
He stays in Delhi.
My lord. His main petition. Correct.
Traveling from Delhi to London on 15th of July 25, and he will be returning to London, Delhi on 14th of September 2025. Stuff.
There is no direct flight from US. It is from Delhi. That is what I know.
Same,
London.
same, এটা হবে
Via
No,
Delhi.
no direct.
No direct.
এই যে এখানে রয়েছে টু সবটাই হবে prior to flight tickets prior to এটা হচ্ছে জুলাইতে 15ই জুলাই যাবে তো by 10th of July will you be able to submit the undertaking with the flight tickets and everything? Today is 3rd.
Absolutely.
10th of July. এই জায়গাটা হবে 10th July. এইটা 3 থাকছে, 4 থাকছে, 5 থাকছে। ঠিক আছে। All right. And where is the undertaking and everything that
For
you've
page
given?
5,
You,
my lord.
very well. You
In the sub
everything you'll supply before the authority.
Absolutely, my lord. That was an earlier order also, my lord. Para 4 subject to correction by your lord.
Yes.
And we had
Yes,
complied
post.
with that.
Can
And my lord, as my learned friend has rightly pointed out, there is no direct flight from Kolkata to London.
Your Lordship, I'm traveling in August to US, and so we have to take a flight via Delhi.
Direct flight, everything is from my lord Delhi.
No, but the person stays in London, Delhi.
He's permanent resident of Kolkata, but he's presently staying in Delhi.
All right. What is this? This is the
No, my lord, notice to the
notice. Notice, please keep the notice on record.
most obliged. Most obliged.
Item number 375, Lordship, ADR pension matter. Lordship, kindly divide me given, Lordship, Treasury Officer as a contemptor party, Lordship, DI and Director of Pension Provident Fund issued PPO. Lordship, Treasury Officer has not released the amount, Lordship, interest amount. That's why I have, my lord, kindly amend the.
Will it be a contempt?
Yes.
Was the Treasury Officer a party in the writ petition?
No. Read petition party, Lordship.
Writ petition he was a party.
Yes.
In the contempt he is not a party.
No. Lordship directed the DI. DI. That's why DI already submit all paper already been submitted to the DPPG.
Yes.
And DPPG issued the PPO.
Yes.
And Treasury Officer, my lord, only
Not releasing the money.
released the only ADR pen matter, not interest part not been released.
All right. 375 টাকে উপর দিকে দিয়ে দেবেন. Are you aware who your other side is?
Yes, Molloy Singh, Lordship.
Molloy Singh is there.
Lordship, last occasion he appeared.
He appeared.
Yes.
Give a notice to him. Come back. এটাকে একটু উপর দিকে তুলে দেবেন.
Get.